It appeals of 2020.
Read appeal.
2019 declaration of service, my lord.
Pardon to myself, criminal appeal, I have for bail, my lord, 9 year.
Read appeal 18 regular.
Hmm?
Read appeal 18 regular.
Matter is compassionate appointment and pleading in this case completed. Matter may kindly listed on that and under the heading admission.
CRLA matter for case admission.
Pardon to mention, my lord, CRLA 2023.
For what? Bail or what?
Petitioner is in custody since
Okay, give it. Give it.
JCR
Hmm?
matter.
Give it.
My lord, item number 13. The contracting advocate request me to adjourn the case. As he is failed in the ill. Supporting. Item 13.
30. 30.
Yes.
30.
13.
There, 1.
30.
There, 1.
The counter has already been filed, but from the list it appears that rejoinder is not there. So you are mentioning on whose behalf?
LC route.
Mishra.
Infractions भी है वाला.
Nai council na hai. Not done. So and so. This is now for Mr. Mishra appealing for advocate in Sirao, 6 current adjournment. The matter will be listed in the week commencing from 14th of July 2025. Yes.
My lord, item number 16. On behalf of Shishir Kumar, the family member has died. Today is 10th day.
Item 15,
16.
16.
Affidavit 1.
Shishir Kumar Purohit.
25 or 26. Opposite side. University.
I am for the private opposite party.
All right. Mention is made by so and so. Chief
From Sambalpur University.
on behalf of Mr. Shishir Kumar Purohit, learned counsel for the opposite party, that there is bereavement in the family and the matter may be taken up on some other day.
Yes.
Land counsel for the states, also the land counsel for the opposite party,
Private opposite party, 1 to 24 lots.
or private opposite party at present. Place this matter same date, 14th of July 2020. Yes.
Pay for next week looks.
There is a bereavement in the family and just give him some days or so.
No, at the 10th. At the 10th.
Today is 10th.
Oh,
Next week at least.
Any other.
all right, then make it on 7th of, yes. All right, next.
Supplemental list, item number 1.
So in these cases, I have challenged the order dated 4/9/2024 of land at Cutock Bench. That in these cases, he has not considered the laches and delay of the cases, as well as the entitlement he has appeared in the before the CAD has not been considered. Besides this, he has violated the
No,
guide.
yesterday, we have told Mr. Parhi that when you are challenging the order of the Land and Central Administrative Tribunal, please file the original application, the counter, rejoinder, so that it would be easier for us to appreciate the entire submission.
That's it.
And I think that
All that documents I have annexed here. That's it.
the original applications are there.
Original applications. are
All right, then it's all right. So what is the prayer of the Aditya Kumar Panda,
That's it.
who filed the original application before the Central Administrative Tribunal? What was his prayer before the,
Let's see, he has prayed for the,
come to page number 22. And come to the Roman 2.
22. That is, after hearing the counsels for the parties, be further pleased to cause the order number B3141 CH1 dated 22/6/2017 at Annex A6, and further pleased to direct the departmental respondent to grant notional promotion to the applicant to the cadre of LSG, HSG2 and HSG1, considering the date of grant of TBOP, and give promotion to the cadre to HSG1 non-functional grade with grade pay 4,800 from the date of promotion of his juniors, giving consequential benefit and benefits.
Okay. So
Come to page 27,
plus the reasoning which has been given.
6 and 7 para.
Already we said. Please come to that paragraph which my esteemed brother is referring.
Para 6. In view of the law stated above,
No.
Plus, in view of the law stated above, rejection of the retention only on the ground that the order of Honorable Cuttack Bench, Cuttack is applicable to those officials who had filed OA number 1196 of 2024 and 1213 to 1221 2004 cannot withstand in the eye of law.
next.
And hence the informed order of the rejection is hereby quashed and the matter is remitted back to the respondent to consider the case of applicant for grant of benefits. What has been granted to the applicants in OA number 1196 by 2004, upheld by the Honorable High Court. It is made clear that in the said event, the applicant shall not be entitled to actual financial benefits, and each pay will be fixed notionally, and consequential order to this effect shall be passed by the competent authority. The entire exercise shall be completed within a period of 60 days.
This petitioner's case is different from the case already decided with OA, which has been upheld by this court. Merely because he is not an applicant, you can't extend the benefit of that order which has been judicially determined.
Not sir, that is there also.
Then
But in these cases, little bit difference is there. This is the case, the person who has filed this OA.
No. Have you got the copy of the order of the Land and Central Administrative Tribunal passed in OA number 1196 of 2004 and which was upheld by this court? You say that there is a difference in the factual aspect of those two cases. So you are to convince in what way it is different.
It is.
Have you got the copy of that order with you?
That order copy.
OA number 1196 of 2004, and that was challenged before this court and it was upheld. So we want both the orders.
and in the counter, have you said that there is a difference? In the counter you have filed, where have you said that factually these cases are different? In the counter, show us. In your counter before the tribunal,
Yes.
where have you said that the case of the present petitioner is different than the case which has already been decided by the tribunal? Where have you said that?
So let me explain in this regard.
Has he not taken a ground in the original application that my case is similar to the case of so and so, which was disposed of by this court in the OA number so and so, and it was upheld by the Honorable High Court? Has he not stated that they can be pleading in that light?
Lots of that is there in our this side.
What counter you have filed? Have you disputed it? No, this is not a similar factual scenario. It is totally different. That is the exactly why the relief has been granted to the opposite party, present opposite party, who was the applicant before the Land and Central Administrative Tribunal. So that is how we want to know from you that you are neither filing that OA order, not filing the order which was upheld by this court. Now you are just making a submission that little different. So what is that little different? just unless we see that.
And 4.4 at page 42, specific pleading has been taken by the respondent, who is the original applicant before the tribunal, regarding the order for the tribunal earlier round. And in the counter, also these counter.
In that very 4.4, you see the subparagraph. He has taken a very specific stand before the tribunal that it is worthwhile to mention that several OAs, that is OA number so and so to so and so, were filed before this honorable tribunal in 2004, claiming that the promotion to the higher pay scale of LCSG under so and so scheme is to be treated as regular promotion and not financial upgradation. The honorable tribunal allowed the OA by the order dated so and so. The department accepted and implemented the order on such and such date. Specific stand has been taken.
Lord. Besides this, Lord, with this, the beneficiary of TBOP, those who are in that cadre of postal assistant, in 2017, some of the postal assistant also once again approached the land tribunal regarding this promotion, and basing on this OA number 1196 of 2000.
Produce that order. Let us
Lord,
waste
that is,
time.
running
You're
page
wasting
number 74. Lord.
Second, this writ petition has been filed by the Union of India challenging the order dated 4/9/2024 passed by the Land Central Administrative Tribunal in OA number 631 of 2017. It appears that the opposite party, number one, Aditya Prasad Panda, filed the aforesaid original application inter alia with FRAS to quash the order number so and so 22 number page re Roman 2 re jo likha hai set up likhi. The London Tribunal, after considering the submission made by the London Council for the respective parties, has been pleased to hold as follows. Quote paragraph number 6 and 7. Though the London Council for the petitioner submitted that the factual scenario in case of the applicants in OA number 1196 of 2004 is different than the case of the opposite party number one, but he has neither filed the copy of the judgment which was pronounced by the London Central Administrative Tribunal in the aforesaid OA which was confirmed by this court. Let the Land Council for the petitioners file the two orders by next date, put up this matter in the week commencing. I will file on by 7th week, you can list it.
Lots of.
On 7th of April, July 2020.
Till date, Lord's this IA number 2473, that is stay of the operation of that CAT order.
Sorry, next 7/7/2020. Yes.
So till date, there
No,
has
no
not
question of
been
till date. It is to be, if you not satisfy, then no relief can be granted. Yes. Item number 2.
Item 2.
Okay.
Given instruction, directed to me instruction to the petitioner. So how many days will it take time to repayment of loan? In this regards, directed me to file affidavit. Due to ignorance, I have not filed affidavit, but I take instruction. He is a retired person. 3 to 4 months, except this mortgage.
No, in that way, the submission would not do. It's a question of payment of money to the bank. So we want that whether he is ready and willing to pay and
Ready.
what would be paid. So file an affidavit to that effect. He will tell something, what he will tell, and he will make a submission. Tomorrow he may say that I have not stated and not given such instruction to my counsel. So we want an affidavit of the petitioner that is in that respect.
This is simply buying time. Just see the writ petition prayer. Can the writ be entertained? Can there be an mandamus to the bank to enter OTS?
I'll file.
And this is only sympathetically we are considering. You have to file affidavit. This is no mandamus can be issued.
You have taken
Can
the
only
loan,
request the court.
you are a
Request the
defaulter
bank.
and all these things, you mortgage the property. Now the bank is taking action. You have come for some relief. So tell how you will pay back the money. So the interest must be, they are, so
Come to the point. The mandamus for
the land counsel for the petitioner seeks some further time to file a specific affidavit regarding the readiness and willingness of the petitioner to pay the outstanding dues of the opposite party bank within a specific period. Put up this matter, provision shows the tarikh provisions 14/7/2024.
file an affidavit giving a proposal so that we can request them to consider. That's all.
That is the exact reason why I have not issued to the any notice to the bank. Unless you from your side say something, why we will issue notice? Yes.
Item 3.
But I'm filing application for amendment, formal amendment. And I have a glance to order dated 10/4/2025.
No, there is nothing, there is a prayer that you made a prayer on 1/5/25 that you will file an application for
What has happened?
post title le kon bhul
No,
bale.
it's a petitioner, na delete kariya.
Who not delete kare.
And the name of Pinaki Datta be deleted from the first line of the cost item.
Handwritten one.
It should be in the name designation instead of name.
Senior chief managers.
No, somebody has to represent the.
Yes, madam. Authorized officer from chief manager.
No. Whosoever is, he has to be named in the.
That was a point. Initially, it was not there. The registry pointed out to write the name.
No, this is right.
Yes.
Let it be there.
But the letter on the coordinate page of Chandrapur court said that the name should not be there. So therefore,
No, name should not be there in that manner, as you said. You see, the first it should be mentioned that it should be like this.
represented through.
Represented through so and so name.
So,
You will write the name in the first. That is not
That is to be deleted.
You should have written Cholamangalam investment so and so,
Yeah.
represented through
right.
authorized representative Mr. So and so so and so.
So in
Likewise.
the amendment, have you mentioned in that way?
And
Your name cannot be totally deleted. The name should come at an appropriate place.
Cholamangalam should go up.
in the affidavit, I have mentioned the name.
Cost title is go for.
କେମିତି କଣ କରୁଛନ୍ତି?
Only deletion of the.
1 minute. No. Deletion ହେଲେ କି somebody has to represent na Cholamangalam.
But
Who
an
will-
authorized officer and senior man.
The idea of asking you to do is
And
Cholamangalam through authorized representative Mr. Singh.
I'll not change it.
And you do that. That's better. I ଗଲତ ଅଛି.
No, this is not.
Man,
Only if you are
yeah,
writing
that's
that.
according.
Bring Cholamangalam at the top, represented through so.
Authorized officer.
Firma region. We are just returning it, file it properly, we are adjourning. Mr. Rao, Land Council, seeks some time to.
Or your officer may permit me to correct in the.
No, that
Anything and after.
it's now, everything is now online and this is appearing on telephone. Scanning has already been made, so it will not be proper. Mr. Rao, Land Council appealing for the petitioner, seeks some further time to file an appropriate application for amendment of the cause title of the petition. Put up this matter in the week commencing from 14th July 2025. Yes.
My lord, on 10/4, your officer directed the state to take instruction.
No.
After
We do not know. There is nothing, no order is.
My lord, 10-4, order is there. Order is there.
All right, you first we'll ask state after you correct the petition. Yes,
Okay.
next.
Okay.
Item 4.
Mr. Sahu, yes, be little
Speak
louder.
louder.
Yes, I am Sandeep Kumar Mishra on behalf of Sri Tribunal representing the petitioner, my lordship. My senior is today has gone to see his aging mother that was admitted in the hospital yesterday night.
What was the order passed last time?
So directed me to file an affidavit. As per the proposal, we had given.
85 lakhs you have to pay.
File an affidavit. Have you filed that
I
affidavit?
filed the
And
affidavit.
given the copy?
Copy, sir.
At 10:45 I received the.
Watch your call. ठीक है, all right. Listen,
But lordship's suggestion, we extended the time till 10 July.
Okay.
Lordship suggested.
the affidavit is on record.
These additional copies I
No,
filed
no.
in the counter.
You have already filed before the
Filed.
registry.
Yes, yes.
We will just, that will be placed on them. Yesterday you have filed.
Yesterday filed.
Aja, listen. Mr. Panigrahi, Land Council appearing for the opposite parties number 1 and 2 bank submits that as per the order dated 23/6/2025, he has filed an affidavit before the registry yesterday, indicating therein that the petitioner has to just sort that if the petitioner pays
85 lakhs.
a sum of rupees 85 lakhs against his outstanding dues of rupees 1,17,000.
1 crore. Sir.
1 crore 17 lakhs 5,043 by on or before 10th of July 2025. The bank is ready and willing to settle the account. Stop. Mention is made on by Mr. S.K. Mishra on behalf of Mr. Tunasau that the copy was of the affidavit has been served on him in court today, and he wants to obtain instruction, and the matter may be taken up on some other day. Is this matter? You want it next week? କାରଣ 10 ତାରିଖ
Tuesday, my lordship, Monday or Tuesday.
ହଁ କହୁଛି ସେଇଥିପାଇଁ କାରଣ 10 ତାରିଖ ହଉଛି ଆମର ଇଏ ଟାଇମ ପଳେଇବ
Second July.
so let it be on 2nd July 2025 ହେଲା ଏଇ amount ଟାକୁ ଠିକ ସେ ଦେଖି ଲେଖିବେ ତାର ଗୋଟେ କପି ଦେଇ ଦେଇଛନ୍ତି ଆଚ୍ଛା the affidavit be placed on record then ଲେଖିଦେବା ହେଲା ଏଇ paragraph ଯୋଉଟା ଲେଖିଛନ୍ତି ଏତିକି outstanding dues ଏତିକି ହେଲେ settle କରିବେ ତାକୁ ଲେଖିଦେବେ yes
Item 5.
May it please your lordship. Lord, here the petitioner is a victim of the misrepresentation of the bank. In as much as the petitioner is an auction purchaser who purchased the property, but later on found that there is no road, there is no access to the property itself. The misrepresentation is to the effect that the bank stated in the advertisement as well as the RI report was also given, in where it has been shown that a road is annexed to the property and he has ingress and egress to the main road from that road. But when he went to the property physically, he saw that that portion of the land has already been acquired by the railway and there is no road at all. I'll demonstrate this, my lord, from the annex.
No, how all these things can be adjudicated in a writ petition?
Yes, my lord,
for that,
subject to me as well, my lord.
For that, adducing evidence may be necessary.
No.
You say that they have, let us say they have committed some kind of mischief, some kind of fraud for which you purchased the property, found that there is no.
All disputed facts.
All these disputed
This is
facts.
not disputed because in as much as the letter of the bank says that it is as is where is basis you have purchased. So
It's all right. They on this basis you purchase. Now, whether that is existence or not, for that it may be necessary to send somebody to the spot to verify all these things. to prepare a report, Amin may be sent or somebody.
Perhaps you have to file a suit.
I have.
So better it-
Well,
Whether
that
you
is,
file
that
a
is
suit.
not permitted under the Act. The Act says under the Surface Act, there is a bar for civil suit
So,
in all matters.
no, you have to go to the DRT, not here.
Why not?
Once in the writ petition, how will adjudicate all those matters?
May I permit it, my lord? Very recent decision of this honorable court, my lord. Reported here in 2025, 1 OLR 10367. This question also was raised. There it is identical facts. And there this court has ordered that the land may be handed over as soon as possible within a month, or else the deposit may be refunded with interest. My case is also identical. Your lordship may see that
No,
it is
you
admitted.
you say that land has already been handed over. When you visited that,
No,
but you
land-
found that there is no accessible road.
the land has not been my lord, handed over as yet.
You have already deposited the
No,
money.
not the full amount, about 40% of the
Then?
amount. That
So
40%,
if you have not deposited the amount by stipulated date, they might have cancelled it.
yes, that is forfeited. They are saying that it is forfeited.
No, that all these
That
things
for-
raised before.
My lord,
You are basically agreed by forfeiture.
forfeiture, yes, my lord, definitely, because the land they are not able to provide. Your lordship may see the additional affidavit.
No,
It is admitted by them. That,
raise the dispute before the DRT.
my lord, your lordship may see this
We
decision.
are giving you permission.
Your lordship may kindly, my lord, I'll just.
So many
place-
decisions are there. These two cannot be entertained here.
Here, my lord, the DRT can only be approached under section 17 by the.
That is the original code. That is the
Yes,
original.
section 17, but this kind of cases cannot fall under the ambit of section 17, because once the purchase, the auction is over, the role of section 17 is gets over, my lord.
That is steel oars for in the Bafna Motors. It is you cannot touch it. Say that it is not the remedy.
Yes,
Once
my
everything
lord,
goes-
where the 17 is applicable, then only. Where 17 is applicable, it is
Go
enumerated.
for the suit. Go for the suit. It's not that.
Suit is also bad, my lord. That is the preview.
You are qua the guarantor and borrower. You are a third party purchaser, as a auction purchaser. You can maintain a suit.
No, here my lord, it is an action under the Surface Act. So bar is under the any action under the Surface Act
It is regarding
cannot be
the-
challenged in a suit. That is the bar.
Because your cause is something different. It doesn't fall under survey.
It does not fall under section 17, but the Surface Act is applicable
Petition
in
has
as
been
well
filed
as.
by the petitioner sworn to challenging the order dated.
Your lordship,
So,
we take note of this decision and dispose of, my lord. At my humble prayer, my lord. Very recent
It
decision, my lord.
appears that the petitioner is aggrieved by the e-auction cell notice dated 22/8/2024. So also the also the order dated 31/2025. What is that order? 31/2025?
Additional affidavit B. Flat D.
31/2025, which has been annexed to the fiscal affidavit in which it is stated by the bank that since the petitioner has failed to deposit the total auction amount under the powers and proceedings conferred by the Surface Act, the bank forfeited the partial deposit amount of rupees 16,30,625. A ground has been taken pointing out the representations filed by the petitioner under Annexure 4 series before the Chief Manager, Bank of Baroda, to also the branch head of Bank of Baroda, that he had heard from other local sources that the land is a logged property, and he had given the written application for demarcation. And the land was demarcated by the local revenue inspector and found that the property was landlocked. And that is how a prayer has been made and further it is stated that the road shown by the bank connecting to the property is missing and there is no access to the property, and the bank has misled him regarding the sale of the property with ill intention, for which he has requested the bank to refund a sum of rupees 30 lakhs, that is 22 lakhs so and so, plus interest, plus loss and compensation. After hearing the land counsel for the petitioner and going through the documents filed, we find that these are all disputed facts, and particularly in view of the settled position of law in the case of Bapna Motors so and so, we are of the view that this writ petition is not maintainable. Accordingly, the same is disposed of. The petitioner is at liberty to seek appropriate remedy in accordance with law. Yes, next.
Only prayer if you're not to take note of this decision. The decision.
The Land Council for the Swanso cited the decision of the Swanso. Yes, next.
Item 6, we have filed the petition challenging the order of the CAT, but we have to file an affidavit with all records, we have and other copies. That's why keep you to one cap.
Right.
Only rejection copy and all the way filed. We will file the details.
Mr. Party Land Council, Land Deputy Solicitor General appearing for the petitioners submits that in the writ petition, though challenge has been made by the petitioners, the order dated 2/7/2014 passed by the Land Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 260/00538 of 2018. But for better adjudication of the case, there is requirement of filing the original application, the counter affidavit, etc. And he may be given some time to file all those documents. Put up this matter on 10 days after, means 14th of July 2025. And mention the name of Santosh Kumar Samantray, Land Central Government Council.
Item 7.
Yes.
Today, I am challenging the order passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack, under Annex 11, page 46, my lord. May I come to the operative portion, page 51.
Just a minute. What is challenged in this writ petition? You are challenging the order dated 24/4/24.
24 part. Order number
Under
20.
Annexure 10 is the impugned order.
Annexure 11. My lord, the opposite party challenging the order, impugned order under annexure.
What you are challenging, Land Council for the petitioners, you are challenging which order?
Under annexure 11, my lord.
But in your prayer portion, you have mentioned annexure 10. You have mentioned,
My lord, it is wrong.
अरे wrong माने कौन अपन order dated टा देखूं जाके 24/4/2024 order OA number 751 रे pass ହେଇଛି
Order is also,
How-
date is also wrong.
That
so
order,
date is wrong, annexure is wrong.
no, my lord, actually that order was reserved on 24/4/2020.
When it is pronounced,
Pronounced on 25.
no, that is the date,
That is, yes, ma'am.
not the date when it is reserved. When it is pronounced, that is the date.
You are justifying that mentioning a incorrect thing. You are again arguing that I have mentioned correctly.
No, my lord, I am not.
That is to be, that prayer portion is to be just a little amendment is necessary. File an application, not only you are to
Date and
date and the annexion number, that is to be changed.
Can you give me?
Look, the learned counsel for the petitioner submits that inadvertently in the prayer portion, if khali एठी अछि ना also entire body रे भी भूल करछन्ती.
नहीं,
10 days time रो तापरे चेकिंग करी whatever.
In the prayer portion, the date of the order, so also the annexure are wrong, and therefore he wants to file an interim application for amendment of the prayer portion.
होने जा ठीक लिखते
Leisure ठीक अछि. Put of this matter on such and such date, interim application be filed in the meantime. Yes.
Item 8.
me please.
Yes.
The petitioner. No,
Mr. Jenna?
My lord,
Okay.
the petition is all in ailing person. And
You have filed your Vinama?
na Bhinama ailing ଅଛି ତ ତେଣୁ that is why one week time may be given now he is one bolla. And the petition that opposite party is even deprived for pension for last
Apana,
one decade.
you see, unless you file the Okalatnama, how can we
Yes,
hear you?
But
The problem is that you took time on 17th.
I have already informed that, but I have heard that he is ailing. So, honorable,
We,
1 week time, ma'am, so I will file, ma'am.
the Mr. Jenna submits that the matter may be taken up after the week, so that in the meantime, he will file Wakalatnama for the opposite party. List this matter in the week commencing from 7th of July 2025.
Well, I tell you one thing, my learned friend filed a content petition before this learned state administrative tribunal photo with photo.
What is the number? You don't proceed with the content petition. Which
Well, only notice was issued, madam. Only notice was in the contempt.
What is the date of that content petition?
Contempt of notice was.
11 तारीख ଥିଲା.
ବର୍ତ୍ତମାନ ଏମିତି ଅର୍ଜେଣ୍ଟ ନାହିଁ ତ 7 ତାରିଖ ପୂର୍ବରୁ ନାହିଁ ତ ନାହିଁ ତ
And meanwhile, you file OA, copy of OA and other
Okay.
documents.
The learned counsel for the petitioner shall file the copy of the original application, the counter, etc. in the meantime. Yes.
Item 9.
Mr. Nayak,
Appearing on behalf of Mr. Naik and the actions.
who is your notice most? What is your good name? Please write it. Mr. Swanso, appearing for Mr. S.K. Naik 2, 6 for an adjournment. List this matter. Yes, give it. Next.
Item 10.
Wait, please. Yes.
Item 10, the present petitioner is a licensing officer, and the petitioner is challenging the order passed by the ombudsman. Here, what has happened is the Electricity Act provides for a standard code of procedure whereby if the consumer files an application for getting a new electricity connection, that has to be mitigated within a time-bound manner. If there is delay and lacuna on the part of the licensee, invalid delay without any reason, then he is entitled to get compensation. That is the scheme. For the purpose of compensation, he is to approach the Orissa Electricity Regulatory Commission. the commission has to issue notice and accord an opportunity of hearing to the licensee, then pass an order either refusing or allowing compensation. Now let's hear the case. The present petitioner, instead of the opposite party consumer, instead of approaching the OERC, approached the learned GRF. The learned GRF refused to entertain his application. That was rejected. On merits as well as on the jurisdiction, on merits, the learned GRF said there is no lacuna on the part of the licensee. It was natural calamity beyond the control. Thereafter, after GRF order, he went to Ombudsman, which is the appellate forum for him. The learned Ombudsman allowed his complaint, reversed the order passed by the learned GRF, which is the subject matter of challenge in this writ petition. The writ petition involves two grounds of challenge. One, the primary ground being the jurisdiction ground. This has to be raised before the concerned OERC as per the regular section 57 of the Electricity Act. If your lordship sees the Electricity Act. Section 57, if your lordship.
Electricity Act. He approached whom?
The learned GRF ones. The grievance redressal force.
57.
That I have also quoted in page 14 of my.
No, there's just a bit.
My wording.
Standard of performance of the licensee.
Yes, your lordship sees, may place.
Yes.
The appropriate commission may, after consultation with the licensees and persons likely to be affected, specify the standards of performance of a licensee or a class of licensees. 2. If a licensee fails to meet the standards specified under subsection 1, without prejudice to any penalty which may be imposed or prosecution be initiated, he shall be liable to pay such compensation to the person affected as may be determined by the appropriate commission, provided that before determination of compensation, the concerned licensee shall be given a reasonable opportunity of being heard. The compensation determined under subsection 2 shall be paid by the licensee within 90 days of such determination. Now, Malat's appropriate commission has been defined under section 2, subsection 4 of the Electricity Act. Your lordship.
Subsection 2.
Section 2, subsection 4.
Yes. Regulatory.
There are 3 regulatory commissions: central, state, and joint. The state commission is governed under section 82 of the Electricity Act, which is the Odisha Electricity Regulatory Commission. So, my humble submission is in.
Is it a case of compensation?
It's a case of compensation. The prayer made by the complainant, consumer.
Let us see the prayer.
If your lordship.
Whether he was asking for compensation.
Yes. If your lordship may see the order impugn itself.
Yes.
Page 107, if your lordship sees.
Annexure?
That would be annexure 80, which is the impugn order. Application also have annex, but this will be clarified for them.
Prayer is there.
107, if your lordship sees. Page.
1.
Page 107, annexure 18, if your lordship.
Prayer is reproduced at 101.
My lords, if your lordship sees 107, he confined his prayer to only compensation.
107.
Of annexure 18.
Just read it out.
My lords, page 107, it is observation.
Ah.
Conciliation failed. During hearing, the authorized representative of the petitioner submitted that his prayer for providing remunerative calculation has already been complied. Hence, the only issue that needs to be decided is whether the respondent is liable to pay compensation to the petitioner for delay in providing power supply. I have also annexed his application, if your lordship.
No, what can be said that, let us say that he had at the initial stage, he had prayed apart from the compensation, he had prayed made number of prayers. So if all those prayers would have been there, then there is no dispute that the right forum is the grievance redressal forum.
My humble submission is he has prayed himself.
109. This 109.
Page
109. The award is a compensation to the petitioner. It is
No,
impossible.
if it would have been only prayer for compensation. See,
He could not have awarded
no,
compensation.
no, you mean to say that,
Compensation.
are you,
Or he can do it without hearing, as per 57.
no, whether in the grievance redressal forum, there is no power for the grievance redressal forum to award compensation.
My love, the grievance.
Let us come to that, which is the, what are the powers of that?
Yes, I'll just show one circular in the book itself, which says any dispute which can be decided by the commission or after.
No, my brother is asking whether compensation could otherwise be paid apart from 57.
No, my lords, because his specific prayer is under the standard procedure. He wants a prayer that is at page 44. He had made a specific prayer that he wants compensation under that.
That is 57. It falls under 57.
Yes.
That's what it is.
Page 44, if you're also.
The prayer is at 54.
Prayer is at 54.
Yes.
That is the very basis of his. This
prayer is at
45.
45.
That is the first petition.
So, you see that compensation part is number 2.
Number B. B.
But the first one, to issue remunerative calculation by which the OP asks to the complainant to invest distribution network with an amount of rupees so and so.
Yes.
And to issue number next to issue a up-to-date bill. So these are the prayer which
he initially made before the GRA.
He could have maintained prayer A, but he could not have maintained prayer B, and which is ultimately the ombudsman has awarded B,
GRF,
which is barred under 57.
That's
this writ petition has been filed by the petitioner, executive engineer, so and so, challenging the order passed by the Learned Ombudsman 2, dated 8/5/2025 in consumer representation case number so and so, via annexure 18. The Learned Counsel for the petitioner, referring to the we vary that grievance petition.
That is annexure 44. Page 44 is the
page 44, no?
45 is the prayer.
45. Referring to the CC number 97 of 2024, which was filed before the grievance redressal forum, pointed out that the opposite party number 2, Sunil Kumar Linka, the consumer, made the following prayer, that is, quote कर देवे prayer portion रे 45 रे अच्छी ते जो chapter का prayer. He submits that when the matter was taken off,
GRF rejected his
application. The order dated 29/2024, the GRF rejected the prayer in toto. Which was challenged by the opposite party number 2 before the Ombudsman -2, Odisha Electricity Regulatory Commission in consumer representation case number so and so, annexure 18 ने लिखा है. And during hearing of the case, the authorized representative of the opposite party number 2 submitted that so far as the prayer number 1 is concerned, which was made before the grievance redressal forum, that has already been complied with by the petitioner, writ petitioner, and the only issue that needs to be decided is whether the petitioner is liable to pay compensation to him for delay in providing power supply. The Land Council referred to Section 57 of the Electricity Act 2003, which states inter alia in subsection 2 that if a licensee fails to meet the standards specified under subsection 1, without prejudice to any penalty which may be imposed or prosecution be initiated, he shall be liable to pay such compensation to the person affected as may be directed by the appropriate commission. The Land Council submits that appropriate commission has been defined under section 2(4), which reads as follows, quote, and this one. It further submits that in view of the aforesaid two provisions, it is very clear that so far as the compensation part is concerned, it could have been only dealt with by the appropriate commission, which is Commission
OERC.
Orissa Electricity Regulatory Commission, and not by the Ombudsman. And therefore, the impugned order is liable to be set aside. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. No notice be issued to opposite party number 1. So far as opposite party number 2 is concerned, requisites for issuance of notice by speed post with proof of delivery be filed within a week, matter be placed after 4 weeks. IN number 9861 of 2025. There shall be a stay of the operation of the order dated so and so until further orders. Yes.
Item 11.
Mr. Behra, এটা কোন একটা dispose of কেসটা আছে court order number 5, the date of the order inverted into transfer instead of 1916. আচ্ছা লিখি দাও। Here you the office note which indicates that the order number 5, the date of order number 5 has been inadvertently typed as 19/5/2025 instead of 19/6/2025. It may be read as 19/6/2025, and making the correct date, the order may be again uploaded. Yes.
Item 12.
Mr. Mishra.
Yes. There is an appeal, it is the order of the single judge.
With the other side, Mr. Mahanti.
I have received only the limitation notice.
Oh, main copy that.
Today, in course of the day, because
No, no, no.
case is not admitted. Case is not admitted.
Just a minute. Delay has already been condoned.
Yes.
So, therefore, you have, by that time, you have already entered appearance. So you mean to say that writ appeal copy has not been served on you?
Well, only proposed limitation notice is served upon me.
You have copied
In course of the day, today itself.
Mr. Mahanti, Land and Council, appearing for the respondent, submits that he has not been supplied with the copy of the writ appeal. Mr. Mishra and Council, appearing for the appellants, submits that he will supply the copy of the writ appeal to Mr. Mahanti during course of the day.
Yes.
List this matter in the week commencing from 7th of July 2025. Yes.
13.
13 has been adjourned, 14 it will be.
My lord, may I pray? They have to admit he. So,
Hold on.
yes,
Mr. Mishra, please come. Please mention.
officer admit he.
Yes.
So I pray let it press admission. After
So,
notice
is it
heading
going to ଯାଉଛି ଯାହା?
ଆସୁଛି ପଢୁଛି ତ ପ୍ରେସ୍ ଆଡମିସନ ଆସୁଛି କଣ? Yes. Next.
ଆରେ ଇଣ୍ଟରଭ୍ୟୁ ଫର୍ମାଟ୍ କଣ?
Entry model.
ଅଛି ସେ
କୋଉଠି ଦେଖିବେ?
ଲାଷ୍ଟ ଆପଣ କଣ୍ଟିନ୍ୟୁ କରେଇଥିଲେ।
Just a minute. Acha. Entry model defects so and so passed in this case number so and so shall continue till next. Yes.
May I take your lordship? Lordship
14.
Before my lord senior serving lordship kindly have a glance to order dated 27/2/2023. Where this honorable court has been.
Mr. DC held summons so and so land counsel for the petitioner seek some time to produce the copy of the writ petition which was filed before the Kolkata High Court, subsequently transferred to the so and so for adjudication and dismissed, and as such the said order was
Noting is that,
was preferred before the apex court when next day.
noting is that this copy of the writ petition and order of in itself as per order of such and such not received.
My lord, while this case was listed before that court, my lord, court wanted to give one copy of the writ application which has been filed before the Calcutta. But that was in 2087, my lord. I have said that I will try to my best to obtain that writ petition, but writ petition, the petitioner is 91 years old. The writ petition filed before the Central Calcutta High Court, which has been transferred to Central Administration.
No, why it was that writ petition was called for, or the court wanted to see that?
Court wanted, I have no answer.
अरे आपण माने थिबे कोर्ट रे
ना,
कोन
मुझे
टाइम कोर्ट मनु कर देथि
The court case mention hala se कहले जो kindly give that.
there must be, the court must have found that there is some connection of the factual aspects of this case with that case.
But this case was transferred from Calcutta to Central. That is, lordship kindly have a glance to page 252, paragraph number 12. That is why this was called.
Page
252.
252.
Paragraph number 12.
Paragraph
12.
In obedience to the direction of the Honorable Supreme Court, we sworn so the entire records and found that the applicant has unnecessarily and luxuriously litigating without any semblance of or imprisonment of any right or entitlement. We could have imposed heavy costs on the applicant for wasting the valuable time of the judiciary. For not only of this tribunal but of the High Court and Supreme Court again and again, time and again, in respect of the cases which have long since been concluded during 1993, but by way of judicial restraint we refrain from the.
May I submit, my lord? Initially, this case was I put Calcutta High Court. I'm telling you, my lord. That has been transferred to Calcutta Administrative Tribunal. They have the petitioner along with 204 others. That case was dismissed by the Central Administrative Tribunal for Calcutta. Calcutta bench dismissed the case of the petitioner.
Yes.
Then they went to Supreme Court.
Yeah.
In Supreme Court, in CA, case was allowed and given a direction to give certain benefits, my lord. They have granted, but factually, one part they have not granted. Thereafter, they have filed a contempt before Supreme Court. Supreme Court held that there is no, you place them in this scale and thereafter give promotion, madam. All the two, that order has been implemented. Order has been passed to implement that order. So far as 204 applicant petitioner is concerned, while except Waltier and Khordha division, Bilaspur division and Calcutta division, they have implemented. Thereafter, since the petitioner has not been given benefit as per the direction of the Supreme Court, they approached the Calcutta Tribunal, which initially in 97. Subsequently, Calcutta that has been transferred to Court of Bench in 2005, and they have said the petitioner filed a contempt application. In contempt application, the opposite party said that give 6 months time to implement the order, since East Coast Railway and Volunteer Division has been newly created. Thereafter, they have passed an order saying that they have implemented the order of the apex court prior to filing of this original application. And also, they have stated in an affidavit stating that the order passed in 2093, 14/5/93, has been implemented in 90 minor. Thereafter, he has filed another contempt application for criminal contempt because you have given a false affidavit. Both the cases, contempt petition have been dismissed. Thereafter, he has approached this court in writ application. This court held that it is not maintainable. Thereafter, he went to Supreme Court. And the Supreme Court says.
What is your claim? You have been fighting it out from 90.
My lord, all those who are in 420 scale, they should be placed in 550. Thereafter, so much on that.
When you are retired? When have you retired?
91. This picture is 91. But during
you have not left the entire India, including Calcutta, Orissa, Delhi. Where have you left then? You have been litigating everywhere.
My lord, in spite of that, my lord.
How many times?
When you are making such submission that the person similarly situated, when they approached the Central Administrative Tribunal, Calcutta, they got the relief. They were denied of the relief, and ultimately Honorable Supreme Court gave them the relief, and by virtue of which they got the relief. And you are similarly situated.
Not similarly. I am the petitioner also, along with them.
Right. So that is the reason why this court passed the order last time that you produce the order of the tribunal, you produce the order of the Supreme Court.
Supreme Court order that has been given.
No, but unless we see the proceeding before tribunal, whether you are a party or not, how will you know? That is the reason the court says that you filed.
My lord. But they have also admitted that I am the petitioner before the Supreme Court, my lord. And Supreme Court, then like you are saying, Supreme Court, I am one of the petitioner, along with 204 before the Supreme Court, and we got the benefit.
Where is the Honorable Supreme Court's order?
In my written notes department, I have given, and also your lordship.
Annexure 4.
Look, I submit my.
You see, when the court passed the order, you must have placed all those things.
Yes,
if you told before us today, you must have submitted before the division bench, which passed the order, and that is how the court came to hold that these documents are very much necessary for proper adjudication of the case, and asked you. Now you are telling that my client is old. I cannot produce the document. My client is 90 years old.
My humble submission before your lordship, while this matter was taken up by the court, that writ application court wanted to know that writ application. The writ application is not available. Even if SLP available, order has also been given. That is of
SLP full cost title. Where is full cost title? Where from you will get that you are a party? Just see 318. It is short cost title. Even if the first page of then how will you say that you are party to be proceeding? It is a shortcut. S, Sarkar and others.
If you say one of
then
the
my humble submission.
Nimish Charan Mahanti was a party or not?
petition copy ही नहीं अपन देना
No, petition.
केमती जानिबु you are a party before the Honorable Supreme Court. You are neither filing the order of Central Administrative Tribunal nor anything you are. ଆପଣଙ୍କର ନାଁ ଲେଖା ହେଇଛି ଏଥିରେ ଅର୍ଡରରେ
Order, but they have said that I am the petitioner before the Supreme Court also. They have admitted in the orders also. Well, 10 days time, I'll last second.
10 days, 2 days.
Have already taken time 2 years and more, so and you are wasting the court's
I
time.
think, my lord, is
That was the observation was made that you have wasted the time of the court, and the court said that we would have imposed heavy cost on you.
That was the order passed by the tribunal. Whereas I approached the tribunal after, on basis of the order of the apex court, my lord. Apex court said that you don't file contempt application, your liberty is granted to file an original application, and court has seen that the order of the tribunal has been.
We are giving you the last chance. If you don't produce the order, we will pass the order. The land counsel for the petitioner has not produced the documents which was directed to be produced by order dated 27/2/2023. The matter is lingering before this court from 2018. Put up this matter in the commencing from 7th of July
21st. I'll try to follow from the
last chance. The matter is to be listed on 21st one. So, yes.
Yes.
It is made clear that no time will be granted for producing those documents. Yes. Yes, item number?
Item 15.
I have filed an additional affidavit. My lord is saying that just file the reply. He gave a serve a copy on me, man.
But to the additional affidavit filed on 18th of March, I timely replied. And
additional affidavit filed by opposite parties number 1 to 3.
Petitioner filed. 19th, 2025.
Just a minute. Acha, further affidavit on behalf of the petitioner.
My lord.
See what I got. reply upon the issue Aji Douchundi. And you have given a copy of it. All right. You are Mr. Barik, you are appearing for the opposite party number? OSFs. Mr. Barik, Land Council, appearing for opposite party number 1. OSFC files the what is that it's titled as counter affidavit on behalf of the opposite parties.
for all the opposite parties. Because
লেখা ହେଇଛି ତା ଦେହରେ ଯାହା ଆପଣ ଲେଖିଛନ୍ତି ତ ପ୍ରଭୁ ପ୍ରସାଦ ଚୌଧୁରୀ ଫାଇଲ କରିଛନ୍ତି
opposite parties.
ସେଇଆ ତ ଲେଖୁଛୁ ଆମେ ଯାହା ଲେଖିଛନ୍ତି ଆମେ ସେଇଆ ହିଁ ଡାକୁଛୁ opposite parties. The counter affidavit is taken on record. The copy of the counter affidavit has been served on the Land and Council for the petitioner in court today, who seeks some time to go through the same, place this matter, and will be commencing from 7th July 2025. Yes.
Entry order.
Entry order chi.
13/12.
13/12.
2018.
Marco. The interim order dated 13/12/2000. 13/12 na 20
যেটা এক্সটেনশন ହେଇକି আসি অরিজিনাল অর্ডারটা 13/12
13/12
18 মাস নোটিং আছে এতে
petitioner in the meantime so and so deposit no କିଛି interim order ही नहीं 13/12/2018 you are not we are reading it out the one extra copy of the writ petition be served on so and so Mr. Barik, Land Council for the OSFC, put up this matter on such and such. In the meantime, the petitioner shall deposit sum of rupees 30 lakhs in a nationalized bank in a so and so and receive thereof urgent certified copy. What is the interim order?
No, status code is 20th December 2018.
20th pass the interim order dated 20/12/2018 is extended till next date. Yes.
Item 17.
Yes, Mr.
Lord, I'm there.
But I have given a date chart, I think must be there on record. Here the date recovery tribunal appellate, appellate order is the subject matter of challenge.
Annexure 21 is the.
Annexure 21, rightly.
Let us see. Yeah. The portion you have mentioned is Annexure 21, but when we open Annexure 21,
It is 191, I think.
191.
Well, you just mentioned appeal number so-and-so has been dismissed by this tribunal. This appeal is connected, no separate order is passed. So, what is the order passed in 39 of 2020?
So that is at page 184, page Annexure 20.
They are the petitioner, appellants were the Vikram means this writ petitioner.
Yes, sir.
For whom you are appearing, and he challenged the order passed by the DRT in essay number 45 of 2017.
One MA was filed by the bank and one essay was filed by the borrower. But both the applications were had separately and two orders were passed that were challenging two appeals.
So essay was dismissed.
Essay was taken up by the appellate authority for order passed in essay. So that order has been passed that under section 13(8), I have lost the right of redemption. If you lordship turn to page 189.
Yes.
It is seen, last but one paragraph.
Yeah.
It is seen that the borrower can exercise his right to redeem the property only as set out in section 13(8) of the Act, not after the sale notice, and therefore, in this case, it can be seen that borrower had already lost his right to redeem the property. The property has been sold and the borrower cannot claim the property now under section 13(8) of the Act. And the presiding officer would not have any power over and above section 13(8) of the said Act, and such being the case, the point of consideration has been answered in negative. And accordingly,
For a moment, kindly. Well, 21 is passed by the covering the order of 20, Annexure 20. Without challenging 20 only.
That's what I was wondering. 20 has been challenged.
No, not that.
20 and 21, but the
Annexure 20 has to be challenged.
Yes.
20 is challenged.
Because reasoning, everything is there in 20.
Pass any order in 20.
The 21,
in view of that,
if you
That's right, but 20 has to be challenged because 20 is unchallenged, then it will go,
20
you know, it will attain finality. If it attains finality, then 21 obviously is a consequential order.
21 is challenged.
21 is challenged, this is a consequential order of 20.
No, both 20, 21 are challenged.
Both the,
Both.
where is that?
Yes,
In the prayer?
In the prayer, not there.
yes, there.
And if it is copied. In the prayer in the.
Only 21 you have challenged.
Yes.
No, 20.
Just make the little amendment, what is there, is the formality.
Because 21 is a consequential order of 20.
So actually, we are actually challenging 20, 21 both.
But
because
it's not.
This is it's a formal thing. Just today you file or tomorrow we file that interim application, that portion just, it would be added as at,
21.
21 is already there, only 20 should be added. So.
And the only thing is there here, but in view of section 13(8), now already the sale certificate is there. And the sale took place
17.
On 17.
17.
But I am on that, the appellate tribunal has committed an error of law. I am challenging the sale.
So 13(8).
Once the sale is challenged, question of redemption is a subsequent thing. If I don't challenge the sale and simply say for redemption, it is barred. Here in this case, sale is challenged under essay. So court has to examine whether the sale is valid or not. If the sale goes, obviously I'll get back the property.
13(8) will come subsequently.
Right.
Mr. Mr. Land Senior Advocate,
I am appearing along with my friend.
appearing for the petitioner submits that the petitioner has challenged both annexure 20 and 21
20 and 21.
passed by the Lenant Deeps Recovery Appellate Tribunal, Kolkata, in appeal case number
39 of
appeal number 39 of 2020, as well as appeal number 42 of 2020. Since no separate order was passed in appeal number 42 of 2020. However, inadvertently in the prayer portion, it is not mentioned that the petitioner is challenging annexure 20. That is the order dated 6th of January 2021, passed in appeal number 39 of 2020. And the matter may be taken off next week. In the meantime, you will file an interim application to amend the prayer portion for incorporating challenging the order passed under annexure 20. Is this matter?
No, it phase 1 and para 1 of the petition also there is a wrong. Just see. Page 1 at the top in the matter of appeal number 32 of 2020. It should be 42 of 2020. And in the first paragraph, just see, again you have written 32 of 2020. It should be 42 of.
Challenges one so some judgment filed in fix one.
Just check it out.
Appeal number 32. In the prayer portion as well as in the body of the petition. In the body.
Number is
the body 20 is challenge.
But no. In the number is also different. 42. Instead of 42, we have written 32.
He has been out of this site.
Sometimes it happens.
Reasoning would sub 39 that is to be. All right. So it is Mishra, we are listing it on Tuesday, so that Tuesday means it is 1st of July 2025.
First paragraph in the top also.
Permission, maybe we come in 7th minutes.
Upon copy appear good.
Appearing for OP1 and 2. Being assisted by him.
All right, 7th of July 2025. Yes. Yes. I to be filed. Next.
I'm sorry.
Item 18.
Yes, Mr. Acharya.
This petition is challenging the order of the learned DRAT. You know, that
which for the other side? DRAT annexure 12.
Yes. Let's hear before your lordships both.
DRAT has confirmed the order of the DRT or?
Yes, confirmed the order of the DRT, where the order is to the limited extent of condoning the delay in filing of the application under section 70 by the borrower. I am an auction purchaser.
Yeah.
I am an auction purchaser.
You're questioning the condonation of delay.
Questioning the condonation of delay in the application filed by the borrower before the DRT. DRT condoned the delay. Then I challenged it before the DRT. DRT confirmed the condonation of delay, and thereafter I am
concurrent finding discretionary exercise of discretionary jurisdiction.
How much delay actually?
1100 odd days. And I will explain.
There is a pending rate petition in this. Actually, the issue is that whether the DRT can condone the delay or not. That is the only thing that is issue before this. And that has attained finality in Supreme Court order dated in the order of 2021, where they have stated that proceedings under surface area in DRT are civil proceedings and they have the right to condone the delay as per the limitation. That is the whole thing. But They are disputing that part. So they are arguing that
No,
they have no power to
any
deal.
contrary decision that VRT has no power.
Yes.
This honorable court's decision is there, which says DRT doesn't have power to condone the deal.
See, meet with the Supreme Court. Judge.
Yes, this honorable court's judgment is there. But plus there are three issues. First issue is whether they can take benefit of section 14 of Limitation Act on the pretext of the writ petitions pending before your lordships. Second issue is after withdrawing those writ petitions, where they had challenged the auction proceedings of the auction proceedings where I am the beneficiary. After withdrawing simpliciter without taking any liberty from the High Court, whether they are not hit by Order 23, Rule 1, Sub Rule 3.
When the order was passed by this court, that portion has not been mentioned that liberty is granted.
No, simpliciter withdrawn. Filed it in.
So you say simpliciter withdrawn means 14 doesn't take application.
They cannot take benefit of 14.
Expression is pending.
Yes, and the other thing, 3 writ petitions were filed. I will demonstrate, Milas. 3 writ petitions were filed, withdrawn, withdrawn. Third writ petition filed, withdrawn with liberty to approach the bank. That's all. Now, Milas, 14, section 14 is of the Limitation Act, also has its checks and measures. It has a rider that when someone was pursuing a bona fide litigation before a particular court, and that court grants permission. In that event, 14's relief will be granted. Here, Milas, I'll demonstrate. If your lordship will permit, I'll just place my case.
Have you annexed the orders of those 3 writ petitions?
Yes. Milas, I had filed.
No, just show us, then we'll.
Yes.
This is.
For your lordship's convenience.
Yeah.
This matter was heard at length. Then, Milas, the constitution has changed of the bench, Milas, and now it has to be heard afresh. 17 to 25, I had filed a written note of arguments with supporting judgments for this. 17 to 25. Like.
Hey.
Written submission, cause list written submission kept below separately.
Yes, we got it. Yes.
Yes. Now let's.
Page number 911. Yes.
I am praying, Milas, for quashing of the order of the learned DRAT, Milas, which is passed on 20th of September 2022. Now, Milas, I am the successful, your lordship may kindly note this date, I am the successful auction purchaser who participated in the auction that was floated on 18/8/2014. Thereafter, Milas, the auction was held on 23/9.
What type of property it is?
It is a pet and everything.
Now I have property with plant and machinery.
Yes.
Landed property with plant and machinery.
Industrial land. Now I am running my fabrication unit on that.
Okay. Yeah.
The auction was held on 23/9/2014. I was the highest bidder, paid 46,20,000 way back in 2014. Sale certificate also has been issued, Milas. I have mentioned everything in that written. Sale certificate is issued on 1/12/2014. Sale deed has been executed in my favor. And I have been handed over the property since 22/12/2017. Now, Milas, may kindly take the meat of the matter, that is the writ petitions that were filed. Now, your lordships will take the writ petitions that are annexed in my, your lordship, in my writ petition, I have annexed it at page 66. There were 3 writ petitions. Page 66.
All those 3 writ petitions were filed by the one.
Yes.
The first one is WPC 18005.
Again.
What is the order?
Yes, your lordship will see. Well, before your lordship goes to the order, your lordship may kindly see what was challenged. Milas, the writ petition starts at page 68 is the index. And what is under challenge, Milas will see at page 75, the same auction notice where I participated and succeeded.
75.
75.
Yes.
75 internal page 8 लिखा है जी।
नहीं 147
ना
75
ସେଇଟା
77
ସେଇଟା ପୁରୁଣା ନମ୍ବରଟା 147 75 ହଉଛି ରେଟ୍ ପିଟିସନ
हाँ ता देर सेटा अच्छी पारा यो
ଆରା 8
पारा 8 हाँ पारा
अंडर annexure 9 series
running period okay para 8 huh
again
that although
although the OP bank had filed a suit for recovery of its dues up to the date of such and such with interest now published auction notice in the newspapers Indian Express on 19/8/2014 and Odia newspaper 20/8/2014 by inviting intending buyers to participate in the e-auction process which is going to be held on 23/9/2014. So I just wanted to show this is the same auction where I participate. So 23/9/2014 auction. Prayer is at page 77 of the writ petition. In the light of the above facts, pleased to admit the writ petition, issue notice to the opposite parties, and after be pleased to quash the auction notices and sale notice. So, that is something that was under challenge. When the matter comes up for the first time before your lordships, page 79, will see an order was passed. Where your lordships directed.
No.
Page 79.
It is 79. Ah, okay. Yes.
79, 22/9/14 order.
Yeah.
Heard Mr. So-and-so, as an interim measure, it is directed that auction set to be conducted tomorrow may be proceeded with in respect of the property of the petitioner, but no final decision shall be taken thereon without leave of this court, subject to. So, whatever order was given, that was subject to petitioner depositing a sum of 50 lakhs in 2 equal monthly installments. The first installment by such and such, second by such and such. Upon making the payment, the petitioner is at liberty to make a proposal to the bank for settlement of its dues. It is made clear the pendency of the writ petition shall not stand on the way of the opposite party bank in order to consider the proposal of the petitioner in accordance with law. So, it was a conditional interim order.
Conditional order.
That 50 lakhs was admittedly never deposited. Then kindly turn over the next page. The final order.
50 deposited or none of the installment?
None of the installment. So, in effect, there is no substance to that. The interim order could not be carried out.
Yes.
Then page 80. Kindly see the date. 20/11/2017. 3 वर्ष पर after 3 years. Heard learned counsel for the petitioner files a memo seeking withdrawal. In view of the memo, filed the writ petition. In memo filed, the writ petition is dismissed as withdrawn.
Okay, then
there is no liberty whatsoever. Then the second writ petition is filed. Kindly see the next page. This is WPC 7323.
7.
Next page, your lordship.
That is 7323. Yeah?
Again, 7323. Kindly, your lordship notes the filing date.
70.
At page 81.
16.
Again.
But before the withdrawal of first writ petition, it was filed.
Yes. While pendency of the first writ petition, this second
was filed. What was prayer here?
Same prayer. I'll show that to us. Page 91, your lordship will see what was prayed here. Page 91, para 7. Again, the same auction notice, etc. is discussed.
Come to the prayer force.
Prayer is 112. 111. I'm sorry.
Yes.
The petitioner therefore pray that in the aforesaid facts and circumstances, your lordship would be pleased to admit the writ petition, call for the record from the opposite party number 2 and 3, and issue rule nicely upon.
Why the notice annexed 3 and 4?
3 and 4. What is 3 and 4? That is at page 83. Kindly see page 83. What is 3 and 4?
Same
auction notice.
Okay. It was filed on 16.
Prior to the disposal of the first writ.
Yes, Phillips.
8/4/2011. No.
No.
See, just come to page 112.
Again.
At the last, what is this date?
112. Yes, the prayer.
Prayer continues. And what is this date? 18/4/2011.
18, that is the date of the writ petition that they have mentioned. That perhaps seems to be a typographical error. But the writ petition is 7323 of 2016.
When it was filed? When it was filed?
It was filed, that is reflected at page 81.
Dated?
26/4/16.
26/4. So, okay. What happened to this writ petition?
Now we'll see what was the order passed on this at page 114.
Withdrawn.
Third,
114, 114.
20/11/17. Same date as the earlier writ petition.
Acha.
Both the writ petitions were
Together.
Listed and withdrawn. Okay.
Learned Counsel files a memo seeking withdrawal. Writ petition dismissed as withdrawn.
Third.
Third, Millards, is at page 115.
But both the benches are different?
No,
Same bench. It was listed together, it seems.
Together.
It was listed together.
Now, Millards will see the third writ petition at page 115. Kindly note, Millards, the filing date 6/9/2017. This was also during the pendency of the earlier two writ petitions. And this is WPC
86/17.
again 1986.
Of course, they are mentioning that it is connected to WPC number so and so and so.
Yes, that is what they are diligently doing. But Millards, can this litigation be seen to be bona fide?
And notice again 3 and 4.
Yes, same.
Notice.
But they are disclosing that.
Disclosing. I am not saying, Millards, I am not on that. I am only showing whether this can be a bona fide litigation for the purpose of Section 14 Limitation Act.
No.
And Millards,
We'll hear you.
1 minute.
We'll hear you.
now Millards, we'll see the order that was passed in this case at page 133.
133. 133, yes. That is order dated 28/11/2017.
After 8 days.
8/11/2017.
से जो पूर्व दीटा रेट पिटिशन जो विड्रॉ ହେଇଥିଲା तार 8 दिन पर एटा लिस्ट होला. Third, learned counsel for the petitioners and counsel for the bank. Writ petition has been filed challenging the e-auction notice such and such published by bank for auction sale, directing the petitioner to settle the loan account as per the bond. During course of hearing, counsel for the petitioner prays for withdrawal of this writ petition with liberty to approach the bank for redressal of the grievances. Granting such liberty, writ petition is dismissed. So, Millards, now your lordship will kindly state what section 14 says.
Bona fide.
Yes, I'll just read it, Millards. Exclusion of time of proceeding, plus
yes,
section 14. Yes. It is also quoted in my written note.
It's all right. Yes.
In computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, whether in a court of first instance or of appeal or revision, against the defendant shall be excluded, where the proceeding relates to the same matter in issue and is prosecuted in good faith in a court which, from defect of jurisdiction or other cause of a like nature, is unable to entertain it. So, Millards, what is the requirement? And Millards, also subsection 3 of section 14. Notwithstanding anything contained in rule 2.
Wrong proceeding in wrong jurisdiction.
Precisely. So, Millards, there is a requirement of the first court giving a finding that this is a wrong court. You go to the correct court. That is required. And therefore, Millards will kindly, and also Millards, section 14(3), subsection 3, Millards. Notwithstanding anything contained in rule 2 of order 23 of CPC, the provisions of subsection 1 shall apply in relation to a fresh suit instituted on permission granted by the court under rule 1 of that order, where such permission is granted on the ground that the first suit must fail.
It's relating to suit proceeding.
Yes, but Millards,
because in the suit there can't be a condonation of delay. Therefore, the subclause 3 is designed for that.
Yes, but order, what I mean to say, Millards, Section 14 is intertwined with Order 23, Rule 1, Sub-Rule 3 and 4 of CPC.
Withdrawal of suit.
Yes. Withdrawal and abandonment. Here is a case where they have abandoned their rights. They challenge the auction, never take liberty. They have abandoned the right. The same auction, of which I am a beneficiary, has been challenged thrice. Not a single occasion they have taken liberty. In this process, can they be permitted to take refuge under Section 14 of Limitation Act? That is the question before your lordship. Now, what does Section 14?
Let us see the reasoning.
What is the?
Yes.
Reasoning.
Yes.
Come to the reasoning part.
Yes. Only Section 14. Malas may kindly take page 4 of my written note.
No, we'll go to the.
Yes.
Let us see the reasoning.
Very well.
DRT order. First DRT.
164.
164.
168.
No. DRT. First DRT.
DRT.
DRT
order.
This is appellate.
Paragraph number.
Plus DRT order is filed by way of a memo minutes.
That's the parent order.
Yeah, that is the 164 order.
164
DRT. Appellative. Original order is the.
Date of my affidavit. My reply affidavit page 40.
That's the parent order.
Parent order. Yes. Your lordship can see. Page 16.
16 of?
Sorry.
Counter affidavit.
Counter affidavit page 48.
48. I'm sorry. 48.
Annexure B by 1.
Annexure?
B by 1.
B by 1. Okay.
All the objections were taken where I had said that they cannot take refuge of Section 14. Now, Milas, page 54, it starts the reasoning.
Are both the party and filing the reports.
The contention of the counsel for the applicant is that the applicant bona fidely pursued before the High Court of Orissa, Cuttack, from 17/9/2014 to 20/11/2017, challenging the auction sale notice dated such and such. The writ petition has been filed within 26 days from the date of publication of auction notice. Writ was admitted on 22/9/2014 and disposed of on 20/11/2017. Because the first notice, your lordship will recollect, was issued with an interim measure, kept pending for 3 years and simply withdrawn. The present appeal is filed today on 18/12/17. Therefore, the applicant is pursuing the remedy bona fidely with good faith before the High Court. The final order passed in WPC on 28/11/17. Therefore, after excluding the period from 17/9/2014 to 28/11/2014 consumed before the Honorable Court, the present appeal is filed within the statutory period. Millards, it cannot be said to have been filed within the statutory period. It is a perverse finding. Then, Millards, in view of Section 14, it is the same thing is repeated. In view of Section 14 of the Indian Limitation Act, the time period after exclusion of such time period, the essay is within limitation. Such delay is neither intentional nor deliberate one, but caused in approaching the High Court.
You tell me, tell us one thing. The finding of bona fideness is a question of fact or question of law?
Millards, sir, it is, Millards,
it's a question of fact.
Yes, question of fact.
The two court concurrently finds it is a bona fide litigation, and therefore Section 14 benefit is given. Being a question of fact, why the writ court will entertain?
Yes, Millards,
answer that.
Where the finding, question of fact is a the finding on the question of fact is a perverse one, the court can interfere at any stage. Here, Millards, it is perverse. It cannot be a bona fide litigation. How can it be bona fide, Millards, when the writ petition is simply filed and withdrawn without taking any leave, and that too kept pending for 3 years? My learned friend has not been able to demonstrate anything to show that how they were bona fidely pursuing it. So therefore, Millards, I say it is hit by perversity.
Yes.
Then the contention of the counsel for the respondent bank is that the auction sale notice in question was issued on Kodia at Cholda, and the applicant filed a series of writ petitions before the High Court of Orissa challenging such auction sale notice as well as the actions initiated by the bank under SAFESI Act. The mandate of law as well as numerous rulings of the Honorable Supreme Court have categorically held that the remedy against actions taken by a secured creditor under 13.4 as envisaged under Section 17 lies before the DRT, and the Supreme Court has clearly disapproved of writ petitions being filed by borrowers aggrieved persons challenging such actions when the Act itself has self-contained provisions of appeal. In the present instance, the applicants, being aware of such legal position, did not choose to adopt the remedy prescribed under law and filed writ petitions which are in contravention of the views of the Apex Court. All the writ petitions as filed have been dismissed by the High Court, and it is not a case where the High Court has afforded the applicant specific liberty to approach this tribunal in an application under Section 17 of the SAFESI Act. Under the circumstances, applicant cannot take shelter of Section 14 seeking condonation of delay under Section 5 of the said Act for filing the present application under Section 17, since the application has been filed far beyond the prescribed period of 45 days as envisaged under Section 17. Well, may kindly take note of this: 45 days compared to 3 years, more than 3 years. The contention of the counsel for the respondent number 3 contended that in view of the law laid down by the High Courts, different High Courts as well as the Honorable Apex Court, the provisions of Limitation Act are not applicable to the proceeding filed under Section 17, and as such the MA is liable to be rejected. In the case of Ponuswamy and another versus DRT, Madras High Court ruled that Section 5 is applicable to the proceedings under Section 17. The High Court, under the circumstances of the firm opinion that Section 5 is applicable to the proceeding under Section 17. While arriving to the above opinion, the High Court also referred to various judgments of the Supreme Court and High Courts, which have also been referred to by the other High Courts. Madras High Court concurred with the view taken by Bombay High Court in UCO Bank versus Kanji Manjeet Kothari in this regard. Allahabad High Court in State Bank of Patiala versus DRT Allahabad followed the views taken in Madras High Court.
You are not a party to this proceeding. DRT proceeding, you are not a party.
In DRT proceeding? DRT proceeding, yes, we were a party.
Yes.
We were a party. Then, ultimately, for the same view, it is the same thing that is repeated. We kindly straight away take.
Well reasoned. Anyway, appellate tribunal.
This will kindly see last page 64. Considering the facts and circumstances of the case, the present case in the parameter of the decision noted in the preceding paras, and with the object of doing substantial justice to the party is concerned and taking principles of natural justice into consideration as per Section 1925 of RDB Act, and the decisions in Allahabad Bank versus Radhakrishna Methi, I am of the view that sufficient cause has been made out by the applicant to condone the delay, and as such, MA number 1234 is allowed and delay is condoned.
Sufficient cause is shown
as per the learned DRT.
Yes.
Now, DRAT confirms it, which is page 164 of my writ petition. This is an appeal that was filed by me, the auction purchaser, Sanjay Agarwal. Para 15 minutes, where I have taken all the arguments regarding Section 14 and how this liberty could not have been granted. Then, the conclusion is at page 173. Now let's have page 173. On the basis of the discussion made above, I am of the view that the period consumed in pendency of the writ petitions before the High Court shall be excluded, and benefit of section 14 should be granted to respondent 1 in filing the SARFAESI application. Counsel for the appellant placed reliance in the judgment in the case of B. Arvind Kumar versus Government of India, where it was held that it is well settled when an auction purchaser derives title and confirmation of sale in his favor, and a sale certificate is issued evidencing such sale and title, no further deed of transfer from the court is contemplated or required. Reliance is also placed upon the case of K. Chidambaram Manikam versus Shakina, wherein the Honorable High Court has placed reliance upon Arvind Kumar's case. This judgment was confirmed. As far as legal proposition of issuance of sale certificate is concerned, Honorable High Court has settled the law, but in the present case, although there was an interim order passed on 22/9/2014, wherein a conditional order was passed, sale certificate was issued in favor of the appellant. On 1/12/2014, SARFAESI application was filed on 18/12/2017. On the same day, sale deed was executed in favor of the appellant. As far as impugned order is concerned, the benefit of section 14 of the Limitation Act is to be extended in favor of respondent number 1. Accordingly, other issues can be dealt with by the learned DRT. The appeal fails and liable to be dismissed. Order, appeal is dismissed. Since disenrollment, DRT is requested to decide the matter expedition. There is the order of DRT and DRAT. Let's do not consider the fact that no steps were taken by the.
Let us come to the finding at 169, para 17.
As far as applicability of section 14 is concerned, Akshat Commercial versus Kalpana Chakrabarti held that the provisions of section such and such should be applied in appropriate cases. Hence, applicability of section 14 of the Limitation Act cannot be in dispute. Because I am not on the question of.
Yes. Let us read.
In Consolidated Engineering Enterprises versus Principal Secretary, Honorable Apex Court in para 12 of the judgment held that on analysis of the said section, it becomes evident that the following conditions must be satisfied before section 14 can be pressed into service. Both the prior and subsequent proceedings are civil proceedings prosecuted by the same party. The prior proceeding had been prosecuted with due diligence and in good faith. The failure of the prior proceeding was due to defect of jurisdiction or other cause of like nature. The earlier proceeding and the latter proceeding must relate to the same matter in issue, and both the proceedings are in accord. So this is exactly the language of what section 14 itself says. But most importantly, beloveds, the failure of the prior proceeding must be due to defect of jurisdiction or other cause of like nature. Beloveds, it cannot be said that this Honorable Court did not have jurisdiction to entertain that petition, because this Honorable Court had entertained the writ petition in the first instance while granting the interim order. So there was no defect of jurisdiction with this Honorable Court.
No, in the face of section 17, there was a jurisdictional issue in the entertaining the petition.
A question of alternative remedy. And
because of the alternative remedy, the writ was not maintainable, which they have preferred it.
Precisely, Millers. But the question that I posed to myself, Millers, is there is the finding in the order. Where is the finding in the order which says that there is a defect of jurisdiction? That section 17 is there, so party must go to DRT. Nothing of that sort. It is a simple case of filing and withdrawing. File and keep it pending for 3 years and withdraw it. How can it be said that they today were ousted from the High Court because of a defect of jurisdiction? It cannot be. How can it be said?
What is your submission?
You
are not able to deposit that money.
I'm coming to that part.
Yes.
Actually,
he has taken over the position, started business there.
Water has flown under the bridge. That
is not correct.
That is not correct.
There has been status order passed by the DRT, and the possession is in continuing with us, and the sale deed has been executed on the date of filing of the essay. Sale deed has been executed on the date of filing of the essay. He has not taken possession till today also.
No.
That is
running a unit, he says.
Running status order passed by the DRT.
There is nothing on record to say.
Status order of the past.
There is nothing on
ground reality, first of all.
File an affidavit.
File an affidavit.
Let
See,
us
you
know
file an
the-
affidavit with the photographs.
No, just.
He shall admitted, cell deed has been executed on the.
1 minute, we'll see, much water has flown under the water.
He has already started business.
Now,
so I-
let us see that.
Actually incorrect. That-
Let them file an affidavit with the photographs.
Electricity bills and everything.
After arguing for some time, when a submission was made by Mr. Acharya, land counsel appearing for the petitioner, that after taking possession of the premises, the petitioner has set up in industries and industry has started functioning. The land counsel for the opposite party opposed to such submission and submitted that there is no such, there is a status quo order and therefore there is no question of starting any business. Let an affidavit to that effect along with the photographs of the unit in operation, stated to be in operation at the place we filed, put up this matter on 8th July 2025.
And you must,
But if
you must write when the sale deed was executed and everything.
Yes, yes. That much anyway is mentioned here.
Anyway, the photograph along with.
It is mentioned in DRT.
Just file the photograph,
Yeah.
because if in the meantime so much of thing has been done, he has started a business and.
After filing of the SML.
No. You
Water,
are-
but see, if much water is already flown.
You are a man. you are
Even
just
condonation of
delaying
delays.
matter.
2014, 17.
Taken the loan, did not pay, the bank taken actions, third party right has been created, third party has taken the position.
No, you, if you would have deposited 50 lakhs rupees and the extra, another installment, you would have had a case.
No,
That also you
it's
did.
on your
No,
part.
Actually, but in the third writ petition, it was said that we shall approach the bank. Actually, we had approached the bank. We had filed an application with them also.
So either you approach or not approach, fact remains that you have not deposited as per the order of
First
this
writ
court.
petition.
Yes,
First writ
fa-
petition.
first, second disposed of, first and second filed within the particular time. You could not have filed the second one with the self-same prayer. Both were disposed of as withdrawn. Again, another was filed.
Generally, this kind of observation, how observation come? You generally you tell the court that we will approach the bank. We'll withdraw.
When you withdraw,
When
when you withdraw the two writ petition, why did you make a submission that the third writ petition has also been filed on the self-same prayer? Is it not proper on your part?
Actually, madam, why actually this is some
No,
difficulty?
these part.
But first was only sale notice was challenged. Subsequently, auction was held on 23/9/2014. The second was actually when.
See, technically you may have a case, equitably you don't have a case.
Madam,
As simple as that.
All right, we'll take up on the next date, 8th.
Technically you may have a case. But equitably,
It's not a
thinking.
order to continue till next.
madam, actually,
This
this is
matters
why equity I'm telling you
Tomorrow-
that was this.
tomorrow is
It
hard
is a
matter.
property of
Then file
2.5
affidavit, you respond.
2.5 crore. And the sale was done on 39.
Pardon to mention, yeah, Finland is custody since last more than 13 years married. This
Mali, this is CRLA press दिला. Press admission.
Yes, madam,
1700 on behalf of Mishra, I am praying for an adjournment.
we are taking off this death reference case, so. Yeah,
Supplementary list, item number 1.
so. Prakash Behra. Nandakishore Sethi. दिलीप कुमार दास अछंती तो हाँ ठीक है आपण मैंने बसिकिन शुणु आर्गुमेंट आरंभ
Written on the Mr. Mulia, have you interacted with Dilip? Interacted with.
We should proceed.
Additional supplement. Motives.
You have given a copy to me.
Alright, first.
I am also filing additional sub note.
You are CORAM.
I am appointed amicus curiae.
Amicus curiae for whom?
By the order dated 20th February 25.
20th
February.
Oh, it's all right to we here now. Let Mr. Mulia question the matter also. Yes, Mr. Mulia.
Therefore, my lord, DNA says before my.
No, you are. We told you about that. What you have mentioned in the note, argument note.
Respect of motive.
Motive. What have you stated here?
We don't, my lord, we don't.
What, according to the prosecution, was the motive behind the commission of crime?
One is, my lord.
There are two motives attributed. One motive is regarding that money part, where that was supposed to be, they were planning for robbing and all. And second is
political liability due to
election contested with Dilip, Dilip's wife, contested with Dilip, his wife, his mother.
Mother of
This is mother.
appellant number 2, madam.
Contested with
wife of Dilip, madam.
and he was supporting.
Who are the witnesses who depose about that political hostility, and who are the witnesses who depose about the loan account?
PW 36.
Political hostility.
Yes.
Only PW 36.
36, madam, and
PW
9.
33 and 9.
Yes.
PW 4 also.
And about the loan amount, who are the witnesses?
PW 36.
Mm-hmm.
And PW
11.
11
11, 17 and PW 35. And PW 35.
17, 18, 19 and 20.
No,
17.
All are the SSG member now.
17 to
20. All are the members of the self-help group.
what is the precisely that loan amount? What is the prosecution case? I think.
This is Viranju received manner the loan amount from the Annapurna group. This is Viranju Mailan received a loan amount from the Annapurna group.
Annapurna
group.
There was an Annapurna group in the village.
Yes.
And it was the self-help group or what?
Self-help group.
Okay. So some members, some villagers are the members of that group. So from that group, it is stated that he received some loan. Then what happened?
To rob the Mailan, rob the amount. The prosecution case, the rob the amount. The present appellant committed the.
Okay.
But 17 to 20, if you see, they are talking about 25,000.
25 each 6 persons. Here 25 each.
Achha.
The prosecution case is that to rob the loan amount, right? which the deceased Bikram, Biranchi received from that Annapurna group.
Directly didn't receive, Mishra. Directly didn't receive.
No, directly or indirectly, that is the purpose. Ultimately,
Yes, sir.
he received and
From the members of the SSC.
huh.
Maha Maheshwari SSG group.
Annapurna group. If you say it is not directly, then in what way?
Yes, Mishra. What happened, Mishra? 7 members of that SSC, there are some members, Mishra, in the SSC. 7 members of that SSC, they obtained, they availed loan from the SSC. And these persons.
25,000 each.
25,000 each.
25,000 each.
25,000
Yes.
each. And among these 7 members, Mishra, some persons gave 23,000, 15,000, 25,000 like this to the deceased Biranchi Miller.
Okay.
And the purpose was to purchase a pickup van.
To
Pickup van.
So deceased Biranchi wanted to purchase a pickup van.
Pickup van.
And these persons who availed the loan from that Annapurna group on their own, somebody gave 25,000, somebody, that is the prosecution case.
Yes, sir.
But why all the 7 of them have given?
Yes, because Biranchi approves them. You give me some money, I will purchase the pickup van. And previously also Biranchi availed some loan, from some money from other members of the SSC group, and he timely returned that money. In the case diary, the IO has elaborately written that.
Whether those money was received on a particular day or on different dates.
On different dates. Statement of 151, statement of record date.
No, it's all right. So if they have given the money and one bank manager said that money was deposited in the bank.
1 lakh was deposited.
1 lakh was deposited. Why it was deposited in the bank? If he's supposed to purchase that pickup van, why he deposited it in the bank?
That is not in the investigation.
Now, whether the bank said that you deposit some amount and then the balance amount will finance anything like that.
But that is not in the statement of bank manager.
Okay.
And some few witnesses have said that they have received the receipt from the Biranchi. Receipt are exhibited.
Receipt, sir.
The money which was paid by these individuals, PW 17 to PW 20, few of them have said that I have received the receipt from Biranchi. Have you exhibited those things?
Only that statement.
So if they have given the money to the Biranchi and Biranchi kept it within the bank, that amount, that is the evidence, then why the accused persons would come to the house of the Biranchi and to rob the money? Because the money was not in the house.
Yes, ma'am.
Money has already been kept, whatever he has received by way of a loan from PW 17 to 20. If he had already kept it in the bank, then the question of availability of money in his house is doubtful. So if you say that the motive is to commit robbery of that particular amount which had been received by the deceased from different members of the self-help group, that money is not there in the house.
Yeah, but the situation, the fact is that the case of prosecution is 1,75,000 money was availed by Biranchi from the different members of the SSC. And in evidence, it has come that 1 lakh deposit, money was 1 lakh rupees was deposited in the bank. Now, when the bank manager says it was deposited on 9th. Now, PW 36 says before 1 day, Ranja went to the house of Biranchi and he inquired about that money. If 1 lakh is deposited, subject to appreciation of lordship, if 1 lakh is deposited, then 75,000 remains.
No, but as my esteemed brother has stated, that you are to bring material on record that exactly what is the loan amount received. If you say he has received 1,75,000, out of which he has kept 1 lakh in the bank, so 75,000 was supposed to be with him in his house, and that may be the reason for which the robbery was attempted and this murder was committed. But you are not exactly producing the receipt. So the vague statement of the witnesses are there, and from the statements, if we calculate also, let us say we are the amount, is it, it comes to 1,75,000.
That comes to
You have examined 4 witnesses.
Yes.
17, 18, 19, 20.
only 1 lakh.
1 lakh is so
That 1 lakh is deposited.
1 lakh is deposited on 9th.
Yes.
10th.
See, your evidence is very shaky. You are not coming with concrete story.
You are, whatever you are advancing, don't go through those 161 statements. These are not substantive
See the
evidence. The evidence you have examined 4 witnesses. Amount these 4 witnesses have stated to have given to the deceased, if you sum it off, it becomes 1 lakh.
Witnesses have few witnesses have said that 25,000 we have availed, but I have paid 23,000. One of them said that 15,000.
No, let us say
Even if 25,000
it becomes 1 lakh. And 1 lakh if deposited, what remains with him for committing robbery? If your case is that 1,75,000 he had availed, then you are to adduce evidence in that respect, by either by orally or by documentary evidence, right?
That's in page 170, 170 paragraph. 170.
What is there?
That is the statement of PW 36.
Hmm.
PW 36 says, prior to the occurrence on 7/10/2017, occurrence is 10/10. And bank manager says money was deposited only on 9th. Here the witness says, occurrence that is on 7/10/17, while I was staying in the house of Mrs. Biranchi Naik, accused Ranja Sethi had come to his residence at 9 p.m. addressing Biranchi Naik as Bhonaja and inquired about the loan amount received from one Annapurna group and whose account was maintained in a bank of Boinda.
Last time important.
Well, on reply, Biranchi disclosed to Ranja Sethi that he had received the loan money, but same has been kept by one of the member of Annapurna group. It may be Biranchi did not want to say that where the money is kept.
The story, what is the prosecution story in so far as this part is concerned? It's very dicey story coming forward.
Which paragraph, which line you are on? No, yeah, Mr.
Para 3, last line. On reply, Biranchi disclosed to the Ranja Sethi that he had received the loan money, but same has been kept by one of the member of the Annapurna group.
No, let us say that he has stated like that.
They might have presumed that it
let us say either he has kept it with one of the members of the group, or he has kept it with one of the in the bank.
But again, you can see para 5. Para 5. On reply, Rani Naik said that her husband has already gone to the Kishore Nagar to repay the loan, and she does not repay the loan. And bank manager stated my lord, 34. Money was reported on that day, 9.
And the trial court has not believed that robbery story, therefore acquitted.
No. Because if you are relying the evidence of
36.
PW 36, this particular line which is pointed out by my Mr. Mulia is very relevant.
Yes.
Because the deceased disclosed to Ranjoseti. Ranjoseti means accused, appellant number 2, that ମୁଁ ଯୋଉ ଲୋନ୍ ଟଙ୍କା ପାଇଥିଲି ତାକୁ ମୁଁ ଅନ୍ନପୂର୍ଣ୍ଣା ଗ୍ରୁପର ଜଣେ ମେମ୍ବରଙ୍କ ପାଖରେ ରଖିଛି। ଏଇଟା ହଉଛି ଆକ୍ଷରିକ ଓଡ଼ିଆ।
That means
ସେ ଟଙ୍କା ତା ଘରେ ନାହିଁ।
but he knows it.
ଏବଂ ସେଇ ଜିନିଷ ସିଏ ଆଣିଲା ନଲେଜ ହଉଛି କାହାର ନା ୱାନ୍ ଅଫ୍ ଦି ଆକ୍ୟୁଜ୍ଡ ମାନେ ରଞ୍ଜୁ ସେଠୀର ଆଣିଲା ଆପେଲାଣ୍ଟ ନମ୍ବର 2 ର। ତ ତାହେଲେ ସେମାନେ ଏ କ୍ରାଇମ ଟା କରିବେ କାହିଁ ତାର ମୋଟିଭ ଟା କଣ?
ପଇସା ତାଙ୍କ ଘରେ ନାହିଁ।
ପଇସା ଘର ତ ଆ ଘରେ ନାହିଁ। ଆପଣ ଯଦି କେତେଟା ଷ୍ଟୋରି ଆପଣ କରୁଛନ୍ତି ମାନେ ଯଦି କହୁଛନ୍ତି 1,75,000 ଟଙ୍କା ପାଇଲା ଲକ୍ଷେ ବ୍ୟାଙ୍କରେ ରଖିଦେଲା ଆଉ 75,000 ଟଙ୍କା ଥିଲା ତା ପାଇଁ ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ହିଁ ନାହିଁ। ଅଛି କି 1,75,000 ଏଭିଡେନ୍ସ ନାହିଁ। ବାକି ଏଇ ଏଭିଡେନ୍ସ ଯଦି ଆଣୁଛନ୍ତି ଲେଟର ସେ ଲକ୍ଷେ ଟଙ୍କା ପାଇଲା ଲକ୍ଷେ ଟଙ୍କା ଯାକ ସିଏ ଡିସିଷ୍ଟ କହିଲା ଆକ୍ୟୁଜ କୁ ଯେ ମୁଁ ହଁ ଲୋନ୍ ଆମାଉଣ୍ଟ ପାଇଛି ଏବଂ ଲୋନ୍ ଆମାଉଣ୍ଟ ନେଇକିନି ଆଉ ଜଣଙ୍କ ଘରେ ରଖିଛି ୱାନ୍ ଅଫ୍ ଦି ମେମ୍ବର ତାମାନେ ତା ପାଖରେ ନାହିଁ ତ ତା ପାଖରେ ନାହିଁ ତ ତାକୁ ସେଥିପାଇଁ ସେ ଟଙ୍କା ପାଇଁ ତାକୁ ତା ଘରକୁ ଆସିବେ କାହିଁ କ୍ରାଇମ କମ କରିବେ କାହିଁ ମର୍ଡର କରିବେ କାହିଁ ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ ମୋଟିଭଟା ଯୋଉ ଆପଣ ଆଟ୍ରିବ୍ୟୁଟ କରୁଛନ୍ତି it is very shaky in nature. ମୁଁ ଯଦି ଜାଣିଲି ହଁ ତା ଘରେ ଟଙ୍କା ଅଛି ଆଉ let us commit robbery and in course of robbery suppose he creates any hurdle let us kill him so that's a different matter but the money was not with him and they took him with them to see a so that man was not carrying the money. So obviously, if money is there, money is in the house. That story has been disbelieved here. They have been acquitted. So question of that, this is the particular motive for the commission of murder. How far it is believable?
This aspect is not coming very with a clarity. Things are different wings, different
And if it would have been a direct evidence, whether the prosecution has proved motive or not, it becomes very immaterial. But since it's a case based on circumstantial evidence, this motive aspects assumes importance, right? So,
this is what is the first motive is concerned. Second motive again, para 6, through this witness you wanted to bring the second motive also, election thing.
And here on the other day, let's speak already is marked that PW11 that
11
he was examined for that posting of stock.
That also doesn't come very with clarity.
so this is so far as this motive is concerned,
This is all.
right? So we have heard both of you on last scene
And motive.
as well as on motives. Now we'll go to the next one is the DNA testing. So let us come here.
Page 59 to the
Just one second. DNA test report is marked as exhibit
59.
59.
349 volume 2.
349.
Volume 2 is 349 and it is proved by the IO.
PW 40 and 41.
PW 41.
It is proved by PW 41 IO.
And PW 40 is the scientific option.
But he has not proved that.
Not, he is not. 41 through 41.
Okay. So let us come to that to page
The relevant portion that the final glass is 357.
357.
Para 5, 6 times.
There is no seat for the madam. Why is standing? Madam, you please sit. Why are you standing there?
Assisting this side.
Okay. Okay.
Enjoy.
No, I said that seats are available. So. Yes, please.
Paragraph 5, 6 and 7. The allele in the genetic profile generated from exhibit mark O, copies from napkin of accused Babuli, alias Prakash Behra, each of a human male origin, with propound at DYSE 91 locus, reference Journal Forensic Sciences. Numbers of Act 23, numbers of Lucy, the alleles in the genetic profile generated from exhibit A1, copies from sort of deceased Nabok, Ecolobionite, are matching with corresponding alleles in the genetic profile gathered from exhibit mark O, table Roman.
तामने आरो गामछारे जो ब्लड टा पड़ीथिला टिके ब्लड पड़ीथिला सी ब्लड ग्रुप को मैच कला आरो 60 रे जो डिसीज्ड रो 60 रो जो ब्लड ग्रुप मिलला सेटा होची सेम ब्लड ग्रुप एया तो सेम माने तार डीएनए टे सेम एया तो तो डीएनए मैचेस जो एथिपाई प्रथम दरकार ए जो डिसीज्ड रो 60 टा एटा सीजर हे किए सीज बोलो ডিসিজ 60 কে সিজার করছি নাপকিন অ্যাকিউজড কে সিজ করছি
অ্যাকিউজ বিরোধ ছিল নাপকিন ও সিজ বাই এক্সিবিট
wait so number 5 page 357 napkin of appellant Babuli alias Prakash Behera is appellant number 1. Acha. Out of which we start of deceased Nabbo alias Ecolobia. So please tell us that Ecolobia ro 60 ro जोटा मार्क है जी MO9 आउ नैपकिन प्रोड्यूस है जी जोटा रे रक्त बाहरला कहउछंदी नहीं एमओ कथा कहउछ
एमोला मला
7 होची नैपकिन रो मटेरियल ऑब्जेक्ट अच्छा MO7DII
नहीं MO7 तो गामुचा को
नैपकिन तो वर्तमान
second C mylum to manner it was executed mylum 59 mylum also as order state of the additional distribution also can differ the manner it was executed mylum also can the page 423
page
423 volume 2 of paper
volume 2 order sheet
number order number 1
order sheet of trial court order number 109
dated 6/5/2024
6/5/2024
I will permit to placement
just a minute
order dated
6/5/2024
6/5/2024 423 ना
433
order number 09 6524, page number 433. Not 423, no, 433.
433.
6526. Pardon.
Accused person namely Nandadeo Sethi and Prakash Behra are produced from jail custody. Learned PP Hon'Ble is present are on the memo. Sri Pramod Kumar Pradhan, found officer veterinary appointed as SDC to defend the case as SDC BSC Satpathy and others refused to conduct the case. Widow 41 namely Premananda Lenka is present. He is further examined. Exhibit 22-4, 70/2, 56, 57, 52, 56/3, 8/2, 8/3, 6/2, 6/3, 57, 57/1, 58, 59, madam. Is 60 and 6162 are marked without objection from the side of prosecution, without consent of my defense. It was marked, madam.
This is exhibit 59.
Yes, ma'am.
No, without objection, it may be defense, it would have भूल है
Without objection from the side of prosecution.
এটা ভুল ହେଇଯାଇଥିବ order sheet ରେ exhibit list ଟା ଦେଖିଲେ exhibit list ଟା list of exhibits. You come to the list of exhibits in the
page 455.
455. Let us come to that. And exhibit to person.
465. 465. It is without objection.
Without objection means it is always without objection by the defense. That is a typographical error. It's not. No. We are Mr. We could have or the real thing. How a state defense counsel was engaged on the date of trial and he was asked to cross-examine. You
Page 455.
No. ये 109 ऊपर आपण कुहतु ये ऑर्डर नंबर 109 देखिले तो पेज नंबर 433 को आसन 433 पूर्व आगे देखो 433 पूर्व स्टेट डिफेंस काउंसिल ये थिले तांको ना होची विश्व सुंदर सतपथी ठीक तो सी लैटर पार्ट रे देखंतु सी गोटे मेमो फाइल कले 4/5/2024 रे जे आज्ञा
विथड्रॉ
मु पावर विथड्रॉ कली हला तापर देखंतु 6/5 रे टेक अप हला केस अक्यूज्ड पर्सन्स प्रोड्यूस्ड पीपी प्रेजेंट हार्ड ऑन मेमो प्रमोद कुमार Pradhan, front office retainer, is appointed as State Defense Counsel to defend the case as SDC, BD Satpathy and all other refused to conduct the case. 6 तारीख दिन आपण जने एडवोकेट को एंगेज कले as State Defense Counsel. से दिन PW 41 रो एग्जामिनेशन चलला तो कौन एटा माने खेल घर चलछि ना कौन ताकू स्टेट डिफेंस काउंसिल करिवे ताकू डॉक्यूमेंट्स देवे जहाँ से पर्यंत साक्षी ହେଇଛି ताकू देवे और समय देवे से प्रिपेयर हबो ता कोन एग्जामिन कले सी कोन चलला क्रॉस एग्जामिनेशन बी क्रॉस एग्जामिनेशन सेनो केबे करछि से
Cross examination in chief 41 refers to 15/5/2024.
सारी चीफ एग्जामिनेशन है
ये मार्क को मेमो फाइल करिए डिफेंस से मोर ऑब्जेक्शन नहीं हो तो मार्क को 293 294 शेयर कीजिए.
No, that is right, but it is that memo is not there.
Mark लेके 294 मार्क लेवल नहीं order sheet.
And the order sheet should also mention that he has received the police paper. कारण जहाकू आपण दे एंगेज करथिले ता पाखरु पुलिस पेपर बा एविडेंस कॉपी याकू दिया गला ए जो लोकटा को बीएस सतपथी को जे कि नुआ एंगेज कले से जिनस भी नाही आदि रे when we engage some counsel as amicus curiae, what we used to do, we say that give him the paper book and we grant him some time for preparation, then we list it for hearing. It's not that on the same day we'll engage and you mark करदेले आपण विदाउट ऑब्जेक्शन बेली करछंदी सेटारे मेमो फाइल करिया कथा तांकर तांकु गोटे कॉपी दबा कथा जे एई डॉक्यूमेंट्स आमे ये करिवु ता देर से लिखिबे जे वी हैव नो ऑब्जेक्शन और आई हैव नो ऑब्जेक्शन इफ द डॉक्यूमेंट्स आर एग्जिबिटेड ताहले से डॉक्यूमेंट्स गुडा को मार्क हे परिवो
देखिए 290 को शेयर विद द मार्क लागो सेटा ही नहीं.
But whatever it may be, see, let us come to that point that a जो seizure list हला दीटा जिनसर जे deceased रो रक्त deceased रो 60 रे जो रक्त मिलिला सेटा होची गोटे अपेलेंट बाबुली रो 60 रे मिलिला ठीक तो डीएनए हाँ गामछा सॉरी गामछा रु मिलला तो डिसीज रो 60 रो सीजर लिस्ट होची केते एग्जिबिट 19 सीजर लिस्ट ऑफ 60 ऑफ नोबो
napkin of asylum number 1 into 19
ଆଉ କହିଲେ 60 ଅଫ ନବ
8 of number होला exhibit 11
अच्छा ठीक अछि ताले एग्जिबिट 11 होची सीजर ऑफ 60 ऑफ नब 60 ऑफ नब तो देखिन ठीक से बोल हाँ
yes exhibit 11 part of the this is number
ठीक अछि then you come to the other one napkin
19
exhibit 19 देखि दियो तापर हम कोइ
199 पूर्ण रक्त बीजा गामछा 19 पड़ोस आपकी बाबुल प्रकाश वे लोहार कटुरी गोटे पूर्ण रक्त बीजा गामछा
ये बाबुली टू जमु
apply number 1
okay now you tell us who has exhibited this seizure list exhibit 11 and exhibit 19 who are the independent witnesses
witness of exhibit 19 witness of PW 11 and 35
just PW 11
and 35
PW 35
and 19
हाँ 19 टार साखी होजन दिजन 11 और 35
और 41 PW 41
अब PW आईओ अच्छा तो तीनिटा साखी होचंती नापकिन रो सीजर लिस्ट रो साखी अच्छा बाकी डिसीज्ड रो जो नंबर जो 60 जोटार सीजर लिस्ट होची एग्जिबिट 11
PW 7 and 30
PW 7
and 30
PW 13
no PW 7 and 38
PW 38
on production of PW 33
हाँ आईओ की
आईओ 41
PW 41 তাহলে PW 41 ला कॉमन विटनेस बाकी ये एमाने कहउछन सो आगे एटा को देखि दवा PW exhibit 11 को देखि दवा PW 7 कौन कहला पेज कहते हैं PW 7 में
107
ପଢିଲେ କଣ ଲେଖୁ?
On 11/10/17, I was in present post of Kishanagar PS. On that day, he then IAC
ଇଏ ହଉଛି କନଷ୍ଟେବଳ ଗୋଟେ। ପଢନ୍ତୁ।
On that day, he then IAC PN Lenga. She is the wearing appearance of the
PN ଲେଙ୍ଗା କିଏ?
PN I-41.
41
He is the wearing appearance of the district of Karani on production of Constable Rudra Monnai along with this command certificate in my presence. This is the result list marked as Exhibit 9. And this is my signature on its mark 9/1.
ଆଚ୍ଛା ସିଏ ଏଇଟା ହେଇଗଲା ତାମାନେ ଏଇଟା ପିଏମ୍ ଯୋଉମାନେ ଯାଇଥିଲେ ହେଇଗଲା। ନାଉ ୟୁ କମ୍ ଟୁ ଦି ଅଦର ସିଜର ଲିଷ୍ଟ ଏଇଟାର କିଛି ଡାଉଟ୍ ନାହିଁ। ବର୍ତ୍ତମାନ ନାପକିନ୍ ଅଫ୍ ଆପେଲାଣ୍ଟ ବାବୁଲି ଆଲିଆସ ଯୋଉଟା ରହିଛି ପ୍ରକାଶ ବେହେରା।
Schedule 19. Exhibit 19.
ହଁ ଏକ୍ଜିବିଟ୍ 19 ଯେ ସାକ୍ଷୀ ହେଲେ PW11 ହଁ PW11 ତ ଆସନ୍ତୁ।
Page 1149.
114 ତ ଇଏ ସେ ସିଜର ଉପରେ ଯୋଉଠି ପଚରା ହେଇଛି ସେଇଠି ପଳେଇ ଆସିବ। ସେ କହୁଛନ୍ତି ଯେ on the same day last line of
On the same
114
at 9:30 a.m., the police seized the chopper and one blood stained towel on the production of the accused person in our presence. This is the said conference statement of the accused Prakash Mada Exhibit 18. This is my signature on it, marked Exhibit 18/1. This is the said serial list marked Exhibit 19. And this is my signature on it, marked Exhibit 19/1. Both the accused person also signed on the serial list in our presence.
both the sign ମାନେ କଣ exhibit 18 ଟା ଉଠି ଆସିଲେ କୋଉଠି କେତେ ପେଜ ରେ ଅଛି?
confession
ତାପରେ ଆପଣ
18 is confessional.
ନାଇଁ ଆମର
19
11 ଟା କଣ ସିଜର ଲିଷ୍ଟ ରେ କଣ ଲେଖା ଅଛି? exhibit 11 କୋଉଠି ଅଛି? କୋଉଥିରେ ଅଛି? ଭଲ୍ୟୁମ
2 page 279.
279 no this is not এটা হচ্ছে ডিসিড অন প্রোডাকশন जो শব্দ ব্যবচ্ছেদ করে এটা উই আর this is exhibit 11 we are asking you about exhibit 19 19 সিজर लिस्ट टा केते पेज रे अछि
291. 291.
ओके এটা হচ্ছে যে from the place of concealment
Production.
it was produced by accused Babuli alias Prakash Behra right so
there are two witnesses
292 my but serial list both my signature both the appellants. Page 292 back side of the
and Girish Chandra Naik is PW 35, Bipin Naik is PW 11.
And the serial list back side both the appellants signed.
it is not at the instance of only one accused
Only one.
so it appears that both of them signed so how do you say that it was the gamucha of this man appellant Babuli
Prakash Behra.
Babuli alias Prakash Behra. If the seizure list shows that both the appellants had signed the seizure list and ଆଉ ଆର ସାଇଡ୍ ହଉଛି PW 35 ସେ କଣ କହୁଛି?
PW 35, PW 35.
Page 164, volume 1. Page 165.
ঠিক আছে।
After so recurring Akil Babuli led the police along with the witness to the place of hiding to give the recovery of offensive weapon and the bloodstained cloth, which include ammunition. Then police along with the witness moved to the spot and Akil Babuli gave recovery of bloodstained gamucha along with the pottery from a bouncer Buddha of the Boiragi knife. Police took the measurement of pottery and length of pottery would be around 14 inch to 15 inch long. The pottery was
এই ଯୋଉ ସିଜର ଲିଷ୍ଟ ଆପଣ ଦେଖଉଛନ୍ତି ନାପକିନ୍ ଟା ତାର ଡେଟ୍ ଅଫ ସିଜର ଯଦି ଆମେ ସିଜର ଲିଷ୍ଟ କୁ ବିଲିଭ କରୁ ସେଇଟା ହେଇଛି ଆପଣଙ୍କର 12 କେବେ ହେଇଛି 12/10/2017
9ଟା ସିରିଜ ସେମ୍
and it was sent for C examination. Forwarding report टा कितने
14/12/17
अच्छा कौनसी साक्षी এই जो सीजियर लिस्ट बा आईओ एमाने कहउचंती कि जो नापकिन टा आर इंस्टेंस रे गोटे अपेलांट जो इंस्टेंस रे जबत हला तापरे ताकू सील्ड कवर रे रखा गला एवं सेही परी अवस्था रे ताकू पठा गला
प्रोटेक्टेड
माने ठीक कोडी केमिकल एग्जामिनेशन कारण केमिकल एग्जामिनेशन को पठाई जी 2 मास परे. So whether the prosecution has adduced any evidence that after the seizure of the napkin at the instance of the appellant Babuli, it was kept in a sealed cover, where it was kept and why there was delay in sending this napkin for chemical examination.
the PW41 evidence page 198.
PW41 page
198.
198. हाँ कौन पूजी
After recording the exhibit 18, Akil Babuli led to the first place for issuing weapon offense along with the napkin was lying inside the bamboo bush, which was inside the cultural field of one boiling knife, which is jungle area. Akil produced the weapon offense, MO6 and napkin MO7 in presence of witness, Schedule 1135, and then prepared the serial list by exhibit 19, already marked, and exhibit 19/5, the signature thereon. In the said exhibit 19, both the accused persons put their respective signature and said as in marked as exhibit 19/3. Exhibit 19/4 respectively. The weapon offense, which was an iron cutlery, was bloodstained on length of 36 cm. Width of the upper portion of the cutlery is 5.5 cm. Middle portion is 4 cm. The base portion was 3.5 cm without any wooden handle. The said cutlery MO6 was affixed with a paper slip and safe has been marked as exhibit 27, already marked, and my signature there marked as exhibit 27/4, and also contains signature of the Prakash Behra, exhibit 27/3, and with other two witnesses, exhibit 27/1, 27/2, along with the signature of 3 doctors who are given the opinion of the weapon of offense as exhibit 27/5, 27/6, 27/7, 12. I have also seen one old white color blood stain napkin of production of the accused Prakash Behra, and on paper slip was affixed on the MO7, in which paper slip already marked as exhibit 20, in which my signature exhibit 20/4. These two I have
This is
seen
important.
930 plus last time is important.
These
I have
two
seen the
I have
930
these 930.
came from the spot on recovery accused after separately packed.
After separately packed and sealed.
I kept in my
Then I kept in my personal custody.
Just come to that 198 now.
Personal custody.
napkin टा देख बाहर करले कोड पाए napkin कथाटा कोड गई
napkin वाला
जोटा पढुथिले टिके 198 हाँ 198 हाँ कुहतु 198 napkin टा 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 weapon of offense को छाड़ दिया we are on napkin अभी आज पढ़ू नथिले
I also seized.
कोड line
Page 198
केते line पढ़े
After PW12, packet footage of PW12, that's the point. I have also.
अच्छा हाँ
13 line.
I have also seized
One old white color napkin on production of Akpi Prakash Vera, and one paper slip was affixed on MO7, in which paper slip already marked as Exhibit 28, in which my signature Exhibit 28/4. Those two I have seized at 9:30 AM from the spot on recovery of the accused, after separately packed and sealed, and then kept in my personal custody.
This personal
Custody.
custody.
Custody. But kindly see my lord. Page 263, para 929. 203. Para 29.
ये जो ये गुड़ाक आछि तो material objects गुड़ाक कौन करथो original record अछि हाँ ask him to produce the material objects of ये जो line टा जदि आमे पढ़िबा ताले से कहूची bloodstained napkin टाकू जेतेबेले accused प्रकाश बेहरा produce कला सी सेतेबेले ता देहरे गोटे पेपर स्लिप अटैच कला पेपर स्लिप अटैच कला परे ता देहरे सील कला मते सेपरेटली पैक्ड एंड सील माने अर्थात वेपन टा को अलगा पैक कला एटा सो personal custody no we are not on that whether any other witness apart from the IO has stated about keeping the property in sealed cover
11:30, not stated regarding
not
regarding the mileage sealed or packet.
Those who are witness to that napkin 11:35 so PW 11 and PW 35 कोई नहीं about keeping it in sealed cover napkin ro 35 कोई चीज़ लेकिन कौन Eleven कोई चीज़ if so 11 has not stated
35
has not stated about the IO keeping the napkin in sealed cover, right? 35 किंतु कोई चीज़ है बोलते हैं 35 evidence ऐसी हो सकती है
page 166
166 at the top in between
para 6
166
after fifth line exhibit 27 signature Akil Babul MO 6 the said blood-stained gamucha recovered in my presence by the accused.
कोडी पढ़ुचनी कोडी
166 para 6
हां
1 2 3 4 5 6 7 9 MO 7 is the said blood-stained gamucha recovered in my presence by the accused. The paper slip in respect of MO 6 has been affixed on the used newspaper through which the said gamucha was tagged.
Gamucha was pegged by the old newspaper.
Yes. And exhibit 28 MO 6 is the said paper slip affixed on the newspaper through which MO 6 was tagged. And exhibit 28 in the signature compared with the signature victim bearing night, Schedule 11. And the exhibit 28 signature Babura alias Prakash.
It was packed in a new old newspaper.
Old newspaper pack करेगी ना उड़ा paper slip देगी paper slip पे signature नहीं थी हो तो
and personal custody.
35. Stated about. Will be when.
Page 203 of IOL.
203.
203. Para 29. man.
203.
Para 29. Para 29. man. Fourth line. On 25/11/2017, handed over the charge to my successor, Patiyamaji, along with all 11 documents and my items. During the course of my service tenure, I know Patiyamaji and acted with her signature handwriting. During the tenure of her investigation, on 14/12/2017, she has forwarded the mal item to the FSL through order of SDG Athamali, and the report was received directly to court. Patiyamaji was not examined. He sent the article to the FSL mail. He was not examined. He is the IO mail, the second IO.
Subsequent IO.
Subsequent.
She has filed the charge sheet.
Charge sheet mail. He was not examined. When he kept the article mail, nothing is there. As well, it was 41 code of personal capacity.
पर्सनल कैपेसिटी रे रखिकिनी ता देर जो सील ता देले फिर ऑब्वियसली ता पर्सनल सील ना it should not have kept that seal with him.
Then after 1 month he gave it to that Pratibha Maji. Pratibha Maji sent it.
On my 14 bar, after
She also kept for about 1 month. Because she has taken it on 25/11/2017 and sent it after in December, 14 December.
She can the foreign report mail.
20 days.
Does not destroy mail. They are in package, in sealed manner, packed manner. Foreign report of the mail, separation. Exhibit 57, page 343. 343. Page is page 345. Important.
You see that Mr. Tripathi, अपन आउट रे आसन से जो सीजियर लिस्ट से पॉइंट आउट कले से जो नैपकिन रो पेज 291 एग्जिबिट 19 तो come to page 292. Now you see the column number 13. The following properties are packed and oblique or sealed, and the signature of the above witnesses obtained on the body of the property. Number 1 serial number hela gotiye luhara paturi jahar osar swanso property hela seta. 2 रे हला गोटे पुराना भिजा रक्त भिजा गामुछा एई गोटा होची रिलेवेंट धोला रंगर नाउ तार गोटे तळे अछि स्पेसिमेन ऑफ द सील इज गिवन बिलो तेणु जोटा आपण ताकू सील कला परे जो सीलटा सेठी देबे पेपर स्लिप रे सेई सील एठी मारिवार अछि आपणकर बुझिले काहे कि ना जेतोळे मजिस्ट्रेट पाखरे प्रोड्यूस हबो ମାଜିଷ୍ଟ୍ରେଟ ପାଖରେ ଯେତେବେଳେ ସିଜର ଲିଷ୍ଟ ପ୍ରଡ୍ୟୁସ ହବ ଏବଂ ତା ସାଙ୍ଗରେ ପ୍ୟାକ୍ ହେଇକିନି ପ୍ରଡ୍ୟୁସ, ଯଦି ତମେ ପୋଲିସ ମାଲଖାନାରେ ନ ରଖିକିନି କୋର୍ଟକୁ ଆଣିଛ, ତାହେଲେ କୋର୍ଟର ଡ୍ୟୁଟି ହଉଛି ଯେ ଆଜ୍ଞା ଆମେ ଏଇ ଜିନିଷ ଦିଟା ଜବତ କଲୁ ଏଇ ସିଜର ଲିଷ୍ଟରେ, ଆଉ ଏଇଟା ହଉଛି ସେଇ ଜିନିଷ। କୋର୍ଟ ଭେରିଫାଏ କରିବ whether the seal which is given in this seizure list, specimen seal, whether it tallies with the seal which is in that sealed packet or not. तापरे ताकू order sheet रे maintain करिवो, maintain करिकिनी direction दबो that it is to be kept in court malkhana until a prayer is made for sending the all these samples can time to time आसीवो विभिन्न इये रे, तापरे ultimately पठा जीवो forensic science laboratory को जायगा हमको दिनो इटा आनथुलु समको दिनो से आनथुलु। एठी तो टोटल आनी कोर्ट रे तो प्रोड्यूस हेनी, कोर्ट रे प्रोड्यूस हेची जाइकिनी 2 मास परे स्पेसिमेन सील जोटा कि आईओ कहूची मु गोटे देली बेली से सील तार निज पाखे रहिला, जदियो इट रिक्वायर दैट इट शुड बी केप्ट विथ ए थर्ड पर्सन। मु जदी मो सीलटा मो पाखे रहिला, मु जो मैटर ये कली ताले इट कैन बी वेरी इजीली टैम्पर्ड विथ, राइट? तेणु पेपर स्लिप रे जो सीलटा देली इट शुड बी हैंडेड ओवर टू द थर्ड पर्सन, हैला, सो दैट टू प्रिवेंट द टैम्परिंग। तेणु निज पाखे रखिला, स्पेसिमेन सील निजर देला एवं स्पेसिमेन सील दबार जो एविडेंस आसुची तार किछि डॉक्यूमेंटरी प्रूफ आधेरे नाही। एई सीजर लिस्ट ओरिजिनल सीजर लिस्ट ना मो पेपर बुक रे जोटा अछि, देयर द सील इंप्रेशन इज नॉट देयर। So it is only oral evidence of 2 witnesses that was kept in a sealed cover, gamucha. अच्छा, अब बाकी वाला फॉरवर्डिंग रिपोर्ट टा कोटा
Page
340.
343. Any 345
345 5 रासन
column 26. One white color napkin of Baguli Pakastra stained with blood and production of the active Baguli Pakastra on leading to discovery. No packet, no seal is there.
No, packet ऊपर लिखाई दियो ना।
नहीं, suppose जो column देखो ना, first column का, para one column देखो one लिखा seal paper and भलो, seal one भलो, para 20.
अच्छा, इतनी किसी sealed packet नहीं।
किसी नहीं, packet का तो लिखी।
मार्क करूँ तो उसे इसने
26.
अपन देखो एक 2 से फॉरवर्डिंग रिपोर्ट देखो जोड़ा को सील्ड पेपर आछि जोड़ा सब लेखा आइछि, सील्ड पेपर एनवेलप गरला
On page 342 to 334.
हाँ, जोड़ा को सील्ड पेपर आछि लेखा आइछि ना, बट हठात बाकी जो जिंस गुड़ा को से गुड़ा को सील्ड पेपर रे थिला बेली जोड़ा आईओ एविडेंस को आउछि सेमती किछि नाही। तापर पुणी 31 रु चली आइला पुणी सील्ड भायल रहिला ए दीटा रहिला। एटा फॉरवर्डिंग रिपोर्ट, तापर से माने रिसीव करथिबे गोटा से रिसीव करिवे
इसका रिपोर्ट है।
एटा होची रिपोर्टटा, एटा होची द डिस्क्रिप्शन ऑफ द सो एठी देखो एटार वर्तमान एटा होची ओ एठी लिखा है किंतु ओटा सील्ड पैकेट रे थिला बेले
19 तक seal packet 19.
Here it is mentioned that it is in sealed packet.
See, just compare the list. So, particularly SDM thing. Compare the.
हाँ, ताप you may be correct that produce होला पर से टीवी कोर्ट रे सील है कि नहीं जाए, तनु ये को दिन प्रोड्यूस होला, डेट ऑफ प्रोडक्शन 14/12/2017. Let us see the order sheet dated 14/12/2017. এটা নেই সেশনস কোর্ট
445 man. 445.
হ্যাঁ
445.
না না সেটা সেশনস কোর্ট অর্ডর সিট এটা ম্যাজিস্ট্রেট পাকে প্রডিউস ହେଇଛି
SDM. Order sheet of SDM.
SDM কাଇଁ
445.
445 ଅଛି
It is at page 448 minute. Order number 9.
ଆମର ଡେଟ୍ ହଉଛି 14/12
14/12
14/12 ଟା ଅଛି କେତେରେ
448.
448 Reply the case record is put up today as the IIC appeared before the court with prayer to the sent the exhibits so and so on to one under section so and so to the director so and so. Prayer is allowed. Verified the exhibits with the forwarding report and seizure list. Send the exhibits to director so and so for chemical reports so and so. କିଛି ଲେଖା ହେଇନି କାରଣ ଯିଏ ପ୍ରଡ୍ୟୁସ କଲା ତାକୁ ଆପଣ ଏକ୍ସାମିନ କଲେନି କି ଗୋଟେ ହ୍ୟାଣ୍ଡ ଓଭର କରିଥିଲା ନା ତେଣୁ ସେ ଏଭିଡେନ୍ସଟା ରିକ୍ୱାର ଥିଲା ଏଇଥିପାଇଁ ଯେ ମୁଁ ଯେତେବେଳେ ଆଠୁ ରିସିଭ କଲି ଚାର୍ଜ ନେଲି ଯୋଉ ମାଲ ଗୁଡାକ ନେଲି ସେତେବେଳେ ଏଇ ଯୋଉ ପର୍ଟିକୁଲାର ଆଇଟମଟା ନାପକିନ୍ ଆମେ ଏଇଟା ଗୋଟେ ନଉଛୁ ବର୍ତ୍ତମାନ ନାପକିନ୍ ହଉଛି ଆମେ ତାରି ଉପରେ ଫୋକସ କରୁଛୁ ନାପକିନ୍ଟା ଗୋଟେ ସିଲ୍ଡ ହେଇକିନି କଭର ଥିଲା ଏବଂ ମୁଁ ସେଇଭଳି ଅବସ୍ଥାରେ ତାକୁ କୋର୍ଟରେ ପ୍ରଡ୍ୟୁସ କଲି ଏଇଟା ଗୋଟେ ଲିଙ୍କ ରହିଥାନ୍ତା ସେ ଲିଙ୍କଟା ମିସ୍ କରୁଛି ଏଠି କାରଣ ଏଗୁଡାକ ଏଇ ଯୋଉ କାହିଁକି ନା ଆପଣଙ୍କର ଯୋଉ ଅନ୍ୟ ଏଭିଡେନ୍ସ ଗୁଡାକ ଯେତେବେଳେ ଦୁର୍ବଳ ରହୁଛି ସେତେବେଳେ ଏଇ ଏଭିଡେନ୍ସର ତାତ୍ପର୍ଯ୍ୟଟା ବଢି ଯାଉଛି ତେଣୁ ଏଇ ଏଭିଡେନ୍ସଟା ଗୋଟେ ଆସୁଛି ଆପଣଙ୍କର ଗୋଟେ ସିଜର ଅଫ ନାପକିନରେ ଯୋଉଟା କି ଆକ୍ୟୁଜ ରିକଭରି କରିଦେଲା ତା ଦେହରେ ଯୋଉ ରକ୍ତ ଲାଗିଥିଲା ସେଇଟା ହଉଛି ଜଣେ ଡିସିଜ୍ଡର ବ୍ଲଡ ତେଣୁ ତାକୁ ରିଲାଏ କରାହେଉଛି ପ୍ରସିକ୍ୟୁସନ ତେଣୁ ଆପଣଙ୍କୁ ସେଇ ଏଭିଡେନ୍ସଟାକୁ ସେଇ ଷ୍ଟାଣ୍ଡାର୍ଡକୁ ନେଇକିନି ପ୍ରମାଣ କରେଇବେ ଯେ ପ୍ରକୃତରେ ଏ ସିଜରରେ କିଛି ଗଣ୍ଡଗୋଳ ନାହିଁ ତାପରେ ଟ୍ୟାମ୍ପରିଂ ହବାର ପସିବିଲିଟି ନାହିଁ ଏ ଟ୍ୟାମ୍ପରିଂ ନ ହେଇକିନି ଏକ୍ସାମିନ ହେଇକିନି ରିପୋର୍ଟ ଏଟା ସେ ରିପୋର୍ଟ ନୋବଡି ଫାଇଣ୍ଡିଂ କେହି ଚ୍ୟାଲେଞ୍ଜ କରୁନାହାନ୍ତି ମାନେ nobody is challenging that the DNA test report finding is something wrong କାରଣ ସେ ତ କିନ୍ତୁ ଯଦି ତା ପୂର୍ବରୁ ଯଦି ଏଇ ଜିନିଷ ଗୁଡାକ ନ ଆଣିବେ then there is possibility to raise that there may be tampering କାରଣ ଜଣେ ଯେତେବେଳେ ଏଇ ଯୋଉ ନାପକିନରେ 3ଟା ସାକ୍ଷୀ ଇନଭଲ୍ଭ ଗୋଟେ ହଉଛି ଆଇଓ ଆଉ 2ଟା ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ସାକ୍ଷୀ 1135 ବର୍ତ୍ତମାନ ସିଜର ଲିଷ୍ଟ ହଉଛି ଗୋଟିଏ ସେ ସିଜର ଲିଷ୍ଟରେ ଅନୁଯାୟୀ 11 ନମ୍ବର ସାକ୍ଷୀ ଆଉ ଏମାନେ 2 ଜଣ କହୁଛନ୍ତି ଯେ at the instance of let us say accused X it was seized but we verified from the seizure list in fact both the accused have signed ତେଣୁ ସିଜର ଲିଷ୍ଟର ଫଣ୍ଡାମେଣ୍ଟାଲ ପ୍ରିନ୍ସିପଲ ହଉଛି ଯାହାଠୁ ସିଜ୍ କରିବ ତାର ସିଗ୍ନେଚର ନବ ଦ୍ୟାଟ୍ ଇଜ ଦେୟାର ଇନ୍ ଦି CRPC ତେଣୁ whether it was seized at the instance of accused X or it was seized at the instance of X and Y that is doubtful. Number 2, if you have seized, then it becomes about the sealing the articles. Papers, paper newspaper pack कर देले, pack करिकिनी गुड़ेकिनी आपण paper slip देले उठे, paper slip रे obviously तापरे लगेला परे paper slip रे signature नियंती एवं तादेरे seal दियंती कारण तादेरे tampering कले से paper slip टा चिरी जीवो paper slip चिरी गले ତା ଦେହରେ ଯୋଉ ସାକ୍ଷୀଙ୍କର ଯୋଉ ସିଗ୍ନେଚର ଥିବ ସେ ବି ଚିଲ୍ ଯିବ, ତେଣୁ ଟ୍ୟାମ୍ପରିଂ ହବାର ସ୍କୋପ ନାହିଁ, ବଟ୍ ଦ୍ୟାଟ୍ ସିଲ୍ ଇଜ୍ ଟୁ ବି କେପ୍ଟ ୱିଥ୍ somebody else। ଆଉ ମୁଁ ଯଦି ସେଟାକୁ ରିଟେନ୍ କରିବି ତାହେଲେ ଆଇ କ୍ୟାନ୍ ଇଜିଲି ଟ୍ୟାମ୍ପର ଇଟ୍, ରାଇଟ୍? ତେଣୁ ଏଠି ସେ ନିଜେ ରଖିଛି, 2 ମାସ ଧରିକିନି ସେଟା ପରେ ପ୍ରଡ୍ୟୁସ ହେଇଛି, ଏବଂ ଯୋଉ ରଖିବା ପରେ ସେ ଯେତେବେଳେ ହ୍ୟାଣ୍ଡ ଓଭର କରିଛି ଯାହାକୁ ଆଉ ଗୋଟେ ଇନଭେଷ୍ଟିଗେଟିଂ ଅଫିସର, ସେ ବ୍ୟକ୍ତି ଜଣକ ଏକ୍ସାମିନ ହେଇନାହାନ୍ତି, ଏବଂ ସିଏ ତାକୁ ନେଇ କୋଉଠି ରଖିଲେ କଣ କଲେ ଏଭିଡେନ୍ସ ନାହିଁ। କୋର୍ଟରେ ଯେତେବେଳେ ପ୍ରଡ୍ୟୁସ ହେଇଛି ଫରୱାର୍ଡିଂ ରିପୋର୍ଟରେ ଆଟଲିଷ୍ଟ ଦେଖଉନି ଯେ ସେଇ ଯୋଉ ପ୍ୟାକେଟଟା ମାନେ ଗାମୁଛାଟା ଗୋଟେ ପ୍ୟାକେଟ ଭିତରେ ଥିଲା ଏବଂ ସିଲ୍ଡ କଭରରେ ଥିଲା, ସେଇଟା ଦେଖଉନି, ଯଦିଓ କେତେ ଗୁଡାକ ଆଇଟମ ଅଫକୋର୍ସ ଯୋଉ ରିସିଭ ହେଇଛି ଯୋଉଟା ସି ରିପୋର୍ଟରେ ସେଠି ରିସିଭ କରୁଛି ଯେ ସେ, ଏବଂ ଅର୍ଡର ସିଟ୍ ଇଜ ଟୋଟାଲି ସାଇଲେଣ୍ଟ ଇନ୍ ଦ୍ୟାଟ୍ ରେସ୍ପେକ୍ଟ। ଅର୍ଡର ସିଟ୍ ଡେଟେଡ୍ 14/12/2017। So এই circumstanceରେ question ଆସୁଛି ଯେ even if let us assume that the blood which was found on the shirt of one of the deceased tallied with the blood which was found in the napkin of one of the accused, but in view of this background or these circumstances, can we take it as an incriminating circumstance? So this is one of the seizure. What about the other? Napkin ro eta gala ଆଉ ଗୋଟେ କଣ ଫାଇନ୍ ଇଏ କରୁଥିଲେ ମିଷ୍ଟର ତ୍ରିପାଠୀ were placing that DNA test report. We
Two things you are missing.
359.
359.
I place paragraph,
Para 5.
Then paragraph 6.
Paragraph 6. Just 1 minute, give me. PW41 handed over charge to whom? कौन था नाटा कहूला? प्रतिभा माझी। सेटा होची केते पेज कहूला आपण? पेज
203
203 paragraph
29 49
29 तो?
part 29 fourth line.
She has not been examined.
Submitted person.
PW41 has stated about the sealing. of the napkin after its seizure, right? In page number
Case number 198,
para
para 21.
forwarding report of the seized articles marked as exhibit ଯୋଉଥିରେ ସି ଲେକିନ୍ ଥିଲା ବୋଲି ନାହିଁ
57,
exhibit
57,
57 page
page 343, volume 2.
in item number से यार कितना नंबर item napkin रो serial number
Napkin serial number would be 26.
26
Is at page 343.
343.
order sheet of the magistrate serial number कितने हैं date कितने हैं जोड़ा place कर लूँ
Page 458.
page 448 order number कितने हैं
14, 12, 17.
नहीं order number अच्छी की ना
Number 9.
अच्छा order dated 14 12
17.
Nine.
order number 9 order number 9 dated 14 12 2017 Okay, now we come to the next item. 5 है 6 7 है हमें 5 टाकू सार देलु 6 को आसन
DNA profile. Included from exhibit mark 4, purchased from the napkin of Akil Babuli, alias Software, we drop out DOYS 391, locus, reference, Journal of Forensic Science, July 2004, volume 39, number 4, June LPP.
नहीं हमें 8 पर सरला वो बेटा 6 पर सरला हां 7 टाकू आसन
DNA profile generated from exhibit mark Q, purchased from full pen of accused Ranja, alias Nandalu City, is of a human male origin and matching with DNA profile of exhibit L1, purchased from Banyan of the residential.
তাহলে সেইটার ফোন তো সেমটি তো let us say
full point Ranja full pen of Ranja Nandalu City.
हां এটা হচ্ছে আমি নাপকিন র লেখিলু তারপরে হচ্ছে
full pant of Ranja match with banyan of branch.
Full pant of
Ranja match with banyan of branch.
with banyan of Biranchi. This is Biranchi. तो हम कौन तो आगे रंजियार जो फुल पैंट रो सीजर साखी के
Exhibit 1 and 2.
Seizure witness of full pant of Ranja, that is PW.
Appellant number 2.
No.
PW.
Exhibit 1 and 2.
PW1 and PW2. और आयु
PW 41.
PW 41. अच्छा तापरे
banyan
banyan of deceased Biranchi.
Exhibit 10 man.
हाँ अरे सीजर लिस्ट आ गई लेनी
exhibit 1/2.
କୋଉଟା full pant ର?
ଆଜ୍ଞା।
Is it 1/2?
Serial list ହେଲା exhibit 1/2. Now banyan of deceased.
MO 23.
ବିରଞ୍ଚି କୋଉଟା ହେଇଛି ଏମଓ ଫୁଲ ପ୍ୟାଣ୍ଟ ଟା କେତେ ମାର୍କ ହେଇଛି?
Full pant.
କେତେ ମାର୍କ ହେଇଛି?
MO 23.
23. ଓକେ ତାପରେ ବ୍ୟାନିୟନ ଅଫ ଡିସିଜ୍ଡ ବିରଞ୍ଚି
Exhibit 10. Serial list.
ସିଜର ଲିଷ୍ଟ
Exhibit 10.
ଏକ୍ସିବିଟ୍ 10 ସାକ୍ଷୀ କିଏ?
PW 38 and 7.
PW 38 and
7.
PW 7 and 38 and the IO
Ayo.
PW 41
MO 5.
ଆଉ ଏଇଟା ହେଲା ବ୍ୟାନିୟନ ଟା ମାର୍କ ହେଇଛି MO 5
MO 5.
ଠିକ ତ? ଆଚ୍ଛା डिसीज रो सार्ट रो जो येटा से प्रोड्यूस करते हुए आफ्टर पीएम एग्जामिनेशन रो ठीक तो ताले ना खाली एटा उपरे आसन फुल पैंट रो साखी होचंदी 1 के 2 से 41 तब 1 के कौन कोई छी पेज नंबर कहते हैं उसका
Page 95. 95.
это пустая режим PW1 hostile
Who also?
PW2 hostile अरे केवल आओ आईओ PW 41 को आसन पेज नंबर कहते हैं
Page 186.
पेज फुल पैंट ये जो एविडेंस था पेज 1 नंबर 1 नहीं ये फुल पैंट रो एविडेंस टा देखा तो फुल पैंट सीजर एविडेंस टा
Paragraph 19.
19
19.
नहीं सीजर लिस्ट हाउस बरा 1 पर कहते हम तो नहीं
Exhibit 1.
एग्जिबिट 1 टा ना 1 by 1 से जहाँ भी हो पैराग्राफ 19 से उसको विषय लिखना अच्छा 1 by 1 टा केबे सीजर लिस्ट हेले देखिले आई और जଣା पड़ गई 1 by 1 डेट टा केते पेपर बुक पेज नंबर कहते हैं सेकंड पेपर बुक एग्जिबिट 1 that is page 264 गोटे कला रंगर फुल पैंट जहाँ पछ पैकेट उपरे ओनली लेखा थाई स्टिकर लगी थाई रक्त लगी थाई दीटा को साखी इंडिपेंडेंट साखी होस्टाइल हो गले बाकी रहिले हाँ आयु होला 41 उपरोक्त मुकदमार तदंत समय आसामी रंज
23.
Yes, para
190.
23. 199.
23
Then after the person who accused Anja and being led by him, I proceeded to the third place of recovery, which situates on the roadside of Akurgan Pathara Gumpa Road near Pathara Gumpa, in the presence of the witness, Vidal 1 and 2. Accused Anja gave recovery of one black color full pant stained with blood, on which a sticker written thereon as only on the backside of the pant and above black pocket. Then a sticker at the serial list at 12:15 a by exhibit 1 by 2 My signature thereon is Exhibit 1/3 and Exhibit 1/4 is the signature accused Nanda Pichati. Said black color fan of the accused is marked as MO23. The papers is affixed on the packet marked as Exhibit 54 and my signature there and marked as Exhibit 54/1. The signature of the accused marked as 54/2, 54/3, 54/4 are the signature of Schedule 1 and 2. Forwarding report ro serial number kete eta ए जो पैंट रो जेन सेटा देखुथले नैपकिन रो 3 is 9 madam page 345
345
345 कितना नंबर सीरियल 49 forwarding report that is marked as exhibit 57 na exhibit 57 in serial number 29 page 345 टीचर लिस्ट भी किसी लिखा ही नहीं एटा सील करी रखा लागल कारण सेटा गोटे सेटा से जो आरो सीजर लिस्ट सेटा गोटे फॉर्मेट सेटा डिफरेंट फॉर्मेट एटा गोटे डिफरेंट फॉर्मेट रे ए जो सीजर लिस्ट देखंतु ए जो एग्जिबिट 1 टा यार गोटे अलगा फॉर्मेट रहउची आ से जो अपन जे सेटा देखैले जोटा पेज 291 अछि
serial number 30.
हां
That is the format.
हां सी फॉर्मेट रो
Following property the fact and class or
ता देरे 13 टा कॉलम अछि whereas this एटरे 7 टा कॉलम अछि देखछन द अपन पेज 291 को पढे छन जो थरे से जो नैपकिन टा सी जेतला 291 92 आ वेटा होसी 264 कला रंगर फुल पैंट एवं ए कला रंगर फुल पैंट देखो सर्कमस्टांस ऑफ सीजर परे सर्कमस्टांस ऑफ सीजर खाली लिखा है जी आमानी जबत करा गला सील कथा टोटल इथि उल्लेख नाही दीटा जक साक्षी सपोर्ट करना प्रशांत प्रधान आ जितेंद्र जो माने कि PW1 2 हिचन समान सपोर्ट करना सोल एविडेंस इज आईओ आधे ए सीजर लिस्ट मध्ये सील मार्क नाही seal impression is not there in seizure list exhibit 1 by foreign code nahi jacket club ha seta dekhile file
Schedule make use to direct for production of those MOs.
how will show they have already told because hey सोमवार दिन दिन ते पहुंच जाए
it will ये पेज to करा इसमें तो रिसीव को सील होता है
no that they have to explain na
yes one seal packet of containing
eta gota au sit arata madhya achi eta hote ha ei packet nai ei emti avastha se man receive kala emane emti receive kala to court re jetale produce hochi setebale kichi jana poli jara seal ta तो सीटा जदि पकई थिबो ते मजिस्ट्रेट करिवा कथा मजिस्ट्रेट ऑर्डर सीट रे लहिवा कथा जे ये करी कोर्ट रे एमती
compare করো।
And the doubt is whether it is properly sealed, protected or not. Because it remained about 2 months.
2
In the
months.
custody of 2%.
2 persons, right? And 1 person you are not examining that person.
Pratibha Machi, you are not examining. And she has kept it for about 20 days. She has taken it on 17th, 14th of.
अच्छा ये ଯେତେବେଳେ କନେକ୍ସନ ରେ କୌଣସି ସିଜିଅର ହଉଛି କ୍ରିମିନାଲ କେସ ରେ ଏବଂ ସେ ରଖିଲା ସେ ଜିନିଷ ଆପଣଙ୍କର ପୋଲିସ ମାନୁଆଲ କହୁଛି ତାକୁ ନେଇକିନି ପୋଲିସ ମାଲଖାନାରେ ରଖିବ ମାଲଖାନାରେ ଗୋଟେ ରେଜିଷ୍ଟର ମେଣ୍ଟେନ ହୁଏ ତ କୋଉ ଡେଟ ରେ କୋଉ ଆଇଟମ ରହିଲା ଏବଂ ତାର ସେଟା ପୁଣି ମାଲଖାନାରୁ କେବେ ଗଲା ତାର ଗୋଟେ ଫର୍ମାଟ ଅଛି ହଁ ଲେଖା ହେଇଛି ନା କୋଉ ଦିନ ରହିଲା ରହିବ କୋଉ ଦିନ ସେଠୁ ବାହାରିକିନି ଗଲା ସେଇଟା ମଧ୍ୟ ଲେଖା ହବ ତ ଦ୍ୟାଟ ଉଡ୍ ଶୋ ଦ୍ୟାଟ ଏଇଟା ଏଇ ମାଲଖାନାରେ ରହିଥିଲା ହଁ ଦ୍ୟାଟ ଇଜ ଦେୟାର ଦ୍ୟାଟ ଇଜ ଇନ ଦି ପୋଲିସ ମାନୁଆଲ ଏଠି ଆପଣ ତ ମାଲଖାନାରେ ରହିଲା ବୋଲି ବି ଏଭିଡେନ୍ସ ନାହିଁ ସେ
rather contrary evidence.
Best evidence.
I kept it personally.
I kept it in person. माने कौन जेमती आजी नेकिन घरे ना गडरेज अलमीरा रे रखी देला सेही टाइप रो एविडेंस मु मो रखिली मोर क्रिमिनल केस रो सीजर जहा कलो जे तुम कोर्ट रे न प्रोड्यूस करूछो बिकॉज ऑफ paucity of time or it may be necessary to show somebody अच्छा गोटे वेपन टाको आपण सीज कलो तो ताकू रखिले एंड वेपन टाकू दरकार ही पारे वेपन टाकू डाक्टर को पाखे प्रोड्यूस करिया पई टू टेक हिज ओपिनियन दैट वेदर द इंजुरीज सस्टेन्ड बाय द डिसीज इज पॉसिबल बाय दिस वेपन तेणु सेठी आपण रिटेन करिवे इट्स ऑल राइट बट यू मस्ट adduce the evidence where you have kept mu rakhili it is vague it is not permissible you have to keep it either in police malkhana making necessary entry in the malkhana register or you have to produce it in court and so that court can keep it in the court malkhana till you file appropriate application to forward the same for chemical analysis so he evidence are lacking coach here
here my right while I am going to the city mirror one place he has stated that I returned to the police station with all the seized certificates that much only thereafter in his BW 41 is deposition paragraph 23 and 27 he has stated it was in one place it was kept in my custody so what is my custody in another part in paragraph 23 he says in my personal custody but the Malkhana register shows IO kept it in recorded the article in the Malkhana register and it was kept in the Malkhana
कोठी लिखा है जी register प्रमाण है जी
on that point will we may file an application
no Malkhana register the evidence is not there the IO has not stated and that very document which you are telling that is not on record माने exhibit तो ही नहीं IO भी कहीं नहीं तेणु we cannot allow you to fill up the lacuna at this stage trial stage is over now during course of argument these are pointed out by the defense or during discussion now you will say I will file an application to examine the IO will not come she will tell that yes I have to, after the seizure I have kept in Malkhana this is the Malkhana so we will again hold trial here whatever 311 petition 391 additional evidence it cannot be used for filling of the lacuna by the prosecution
that is before hearing you would have done it
ବର୍ତ୍ତମାନ ସବୁ କିଛି ଓପନ ହେଇଗଲା ପରେ ଆପଣ ଯୋଉ ଗୁଡାକ ଫ୍ଲ ଦେଖୁଛନ୍ତି ପ୍ରସିକ୍ୟୁସନ ଆପଣ କହିବେ ମୁଁ ତାକୁ ଏ ସାକ୍ଷୀଟାକୁ ଆଜ୍ଞା ମୁଁ ଗୋଟେ ଏକ୍ସାମିନ କରିବାକୁ ପିଟିସନ ଦଉଛି ସେ ଆଇଓ କୁ ଆଉ ଥରେ ଡାକିବା ଆଇଓ ଆସି ଏ ବିଷୟରେ ଏଭିଡେନ୍ସ ଦ୍ୟାଟ୍ ଇଜ ନଟ୍ ପରମିସିବଲ whether in the case that it is mentioned that he has kept in Malkhana then how do you say
that I care It came to the return to the police station along with all seized articles.
ठीक अछि सेतिकी लेखा इस तो सेठी लेखा हवा कथा I kept the articles in the Malkhana and entered in the Malkhana register. एतिका मध्य सीडी रे नाही. On what basis you say that he kept it in Malkhana? गोटे केस डायरी रे बहुत डॉक्यूमेंट थिबो. Court will consider those documents which have been marked either as exhibit either from your side or from the कारण ता देहरे आपण opportunity पाइले the other side has got the opportunity to examine it, to cross examine it. बाकी जो डॉक्यूमेंट नथिबो आमे ताकू यूटिलाइज केमती करिवो, it would be a surprise to them. एई एग्जामिनेशन जदी हेई थांता कोर्ट पचारी थांता आपण जदी एई एविडेंस देई थांते जे आया आईओ कही थांता आया हमें सीज कला परे मु पर्सनल कस्टडी जगह रे आनिली ताकू मु नहीं मालखाना रे रखिली मालखाना रजिस्टर रे एंट्री कली डिफेंस गोटे चांस पाई थांते पचारी ओ बाबू तुम केस डायरी खोलिलो हमको तारीख रे कोन लिखिचो तादर लिखिचो आनिकिनी से जो जिंस पत्र जबत कला परे आनिकिनी थाना रे मालखाना रजिस्टर रे रखिलो कही थांता कोन नाही मालखाना रजिस्टर नंबर पकेइचो ता देरे को दिन केते नंबर सीरियल केमती रखिलो को दिन नेलो याकु लिखिचो ना नाही मैटर वुड हैव एंडेड देयर तो किछि नाही आपण आज गोटे मालखाना रजिस्टर गोटे आनिकिनी कहबा या अछि से मालखाना रजिस्टर से प्रमाण करेनी दिस कैन नॉट बी द फील ऑफ द लैकुनास ऑफ द प्रोसिक्यूशन कैन नॉट अलाउ
For the tampering part, probable tampering part is different. All these questions are not put to the IO.
No, you are to satisfy whether question has been put or not. That's a different matter. The law requires that it is the duty of the prosecution to prove that after seizure of the article till it reaches the chemical examiner, the entire path is covered by such cogent evidence that there is no, the court will believe that yes, it has not been tampered with.
So who has forwarded the articles to FSL? It is Pratima Maji. You have not examined. Where is the occasion for them to ask these questions? You have not brought him to the witness box.
My humble permission is that they could have asked it to the PW for signature.
आपण आपण तो साक्षी कही नांती आपण से कहिची मालखाना रखिली बेली प्रश्न कोन से पचारिबे व्हाट यू आर एक्सपेक्टिंग फ्रॉम दी जदी कहिनी जे मु ताको आनी मालखाना रखिली ताले प्रश्न से मालखाना ऊपर प्रश्न काई से पचारिबे
show me a single show us a single sentence in PW 41 because where he has said that a word of Malkhana single word.
Yes.
Then where is the question of Malkhana?
From the day one, it is taught to a defense counsel that he should know what not to ask than what to ask. That is the fundamental thing. साक्षी को कौन न पचारिबो सेटा को आगे जानिबा दरकार नले जहा चीफ रे कहि नथिबो सबु जेरा रे बाहर करिकिनी निज विरुद्ध रे आथिबो सेटा को आगे चेक करिवो हला
Para 23 is very clear. Para 23 second line. after making the seizure of recovery articles, I kept in my personal custody with proper packing and seal. He kept it and he passed on after 20 days. He passed on to the other IU, Pratibha Maji.
And subsequently,
Who is the Pratibha Maji kept it for 20 days with her. Thereafter it was sent to SF.
in between.
And Pratibha Maji is not taken.
That's it is right. In between paragraph 23 and giving it to the Pratima Maji, 29 paragraph 27 component, the same thing. He said.
That's the problem.
Dr. Pragya Paramita Pradhan, who last examined the weapon of offense, which was sealed and signed by 3 doctors, such as PW 561, and kept in my custody along with that signature
Then
on the paper.
consistently he says that in my custody all these things were there. Very consistent. We have to take it as if he has kept it in his personal custody. You can't improve it.
Probably I was not.
No, I got the opportunity to argue the first NDPS conviction. What is a French national that was she was arrested from Puri Sea Beach, was having charas, and she was found guilty, and I got the opportunity to argue the matter. 94, and these points which I canvassed, and Justice R.K. Patro, as his lordship's then was, you see how beautifully my lord has written that the claim made by the prosecution that the seized articles were kept in safe custody in police station till they were produced before the magistrate is too tall a claim to be accepted. Besides the swan so lacuna by the prosecution, there is no evidence that the seals on the packets in questions were properly made, remained intact from the date of sealing of the packets till they were opened before the magistrate about 2 months after the seizure. No evidence is forthcoming that the packets were properly sealed in absence of retaining the specimen seal with any reliable person. The apprehension that there was chance of tampering with the packets cannot be lightly brushed aside. The specimen seal was not produced before the magistrate when packets were opened to bring out the samples for the purpose of sending it to this chemical examiner. This line is very important. It is for the prosecution to establish and cover the entire path by adducing cogent, reliable, and unimpeachable evidence that the seized articles were properly sealed and there was no chance of tampering with the packets during the retention of those packets at the police station, and the seized articles were the very articles which were produced before the magistrate for sending them to the chemical examiner. The prosecution has failed to discharge the burden, and no reliance can be placed with regard to this one. So this is the observation. So how this is to be dealt with is way it is to be kept with sealed packet, right? Sealed cover, and seal is to be given. Seal is to be kept with reliable person. It is to be produced, and the court has to compare it so that it would be that entire path would be covered by cogent evidence. So unless you adduce this evidence, एठी आपनकर evidence कौन आछि सी कहला मु ताको पेपर स्लिप रे सीज कर देली, सीजर लिस्ट देखोनी सील हला बेली, तीनटा साखी दीटा इंडिपेंडेंट विटनेस रु गोटे कहिनी सील विषय रे, आउ गोटे कहूची सील विषय रे. सो सील इंप्रेशन ता देरे नाही, आ पर्सनल कैपेसिटी रे रखिला, पुलिस स्टेशन पुलिस मालखाना रखिला बेली ना ओरल एविडेंस अछि ना डॉक्यूमेंटरी एविडेंस अछि. कोर्ट को जेते बेला आसिकिनी प्रोड्यूस होची फॉरवर्डिंग रिपोर्ट रे देखा होची इट इज नॉट इन सील्ड कंडीशन, राइट. मजिस्ट्रेट रो वेरिफिकेशन नाही जे कोनसी सील प्रोड्यूस हेची ता पाखरे टू कंपेयर इट दैट द सील व्हिच वाज गिवन इन दैट sealed packet is the very seal which was produced before him. Evidence in comparing color. So how we will come to that. When these are the lacunas, how can we say that there was no possibility of tampering with the same? ରକ୍ତ ଦାଗ ଆପଣଙ୍କର ୱେପନ ରେ ଯୋଉ ରକ୍ତ ଲାଗିଛି ତାକୁ ଆଣି ଟିକେ ଘଷି ଦେଇଦେଲେ ଆପଣଙ୍କର ତାଠୁ ସାର୍ଟ ଜବତ କଲେ ଘଷି ଦେଲେ ପଳେଇ ଆସିବ ରକ୍ତ ହେଇଗଲା ଆସିଗଲା ଆଜ୍ଞା ସେ ଯୋଉ ତା ଦେହରେ ଯୋଉ ଇଏ କରିଥିଲା ଆ ଦେହରେ ବି ରକ୍ତ ଲାଗିଛି ତେଣୁ ରକ୍ତ ମିଶିଗଲା ଭେରି ଇଜି ତେଣୁ ସେଇଟାକୁ ଅଲଗା ସିଜ୍ କରିବେ ତାକୁ ସିଲ୍ କରିବେ ଆକୁ ସିଲ୍ କରିବେ ତାକୁ ସେଫ୍ କଷ୍ଟଡିରେ ରଖିବେ ସିଲ୍ ଯେମିତି ଟ୍ୟାମ୍ପରିଂ ନ ହବ ତାକୁ ଆଣି ପ୍ରଡ୍ୟୁସ୍ କରିବେ immediately. All these things are required. Otherwise it is very easy to say that ଆଜ୍ଞା ଜବତ ହେଲା ସାକ୍ଷୀ କହୁଛି କାହିଁକି ତାକୁ yes, it is a circumstantial evidence.
And see, if everything is brushed aside and whatever you are saying is accepted, even then the first napkin seizure can be connected with the first appellant Prakash Behra, and the second one is connected with Nandakishore. Both the murder takes place in different two places. And the last in theory is the deceased Biranchi Naik. How will you link all these things? Linking is also very difficult.
So we'll take up this matter on Monday because we have already fixed it. On that day, you produce the report, and at 2 o'clock we'll take up the matter, and you produce all those material objects on that. Who wants to appear through a virtual mode from jail? Counsel is present, and Mr. Mulia filed the additional short note of arguments on behalf of the appellants. We find that the material objects have not been produced. The registry shall take immediate steps for production of the material objects on the next date, which is fixed to 30th of June 2025, and the matter will be taken up at 2 p.m. So, Prakash Behra ଆଉ ନନ୍ଦକିଶୋର ସେଠୀ ଆଜି ଆପଣଙ୍କର ଶୁଣାଣି ତ ଚାଲିଛି ପୁଣି ରହିଲା 30 ତାରିଖ ଦିନ 2ଟା ବେଳକୁ ରହିଲା ଆଉ ଆପଣଙ୍କୁ କୁହାଯାଇଥିଲା ଯେ ଯଦି କୌଣସି ସେ ଫାଶୀ ଯୋଉ ଦିଆଯାଇଛି ତା ବିଷୟରେ ଯଦି କିଛି ସତ୍ୟପାଠ ଦେବାକୁ ଥିବ ସେଟା ଦେବେ ଆପଣ ଦେବେ କି ନ ଦେବେ ଏଟା ଆପଣଙ୍କ ଉପରେ ନିର୍ଭର କରୁଛି ବାକି ସରକାରୀ ଓକିଲଙ୍କୁ ଯୋଉ କୁହାଯାଇଥିଲା ରିପୋର୍ଟ ସେ ମଧ୍ୟ ସେଦିନ ପ୍ରଡ୍ୟୁସ୍ କରିବେ ତାପରେ ଶୁଣାଣି ପୁଣି ଜାରି ରହିବ ହେଲା ତ ସୋମବାର ଦିନ 2ଟା ବେଳକୁ ଚାଲିବ ପୁଣି ଶୁଣାଣି Any other press admission? What is live conviction? So it admit kar diyon, call for the trial court report.
Highly likely.
But the remaining orders matter.
It will come on Monday, but Monday it may not be possible to take up. It will be taken up on Tuesday. Right?